crimes against humanity in the NMAT trials and selected UNWCC cases. So Dominika, please, the floor is yours.
Against humanity applied by the Nuremberg military tribunals in subsequent trials, the definition of crimes against humanity, but also to make a step back and discuss cases and documentation of organized mass violence committed during the Second World War against civilians that was collected and prepared for war crimes trials during the Second World War by the United Nations War Crimes Commission. As Professor Herler has extensively discussed yesterday, the definition of crimes against humanity in the Nuremberg subsequent tribunals jurisprudence, I will just very briefly remind of it and then present those cases from the war years, and also try to show that elements of this definition of crimes against humanity, the contextual elements referring to the organized state directed actions, policy factor of committing crimes against humanity, and of course different types of targeted groups focus on civilian experience, and particular types of persecution were discussed and also documented already during the war, and found their expression on legal debates by the United Nations War Crimes Commission that was discussed yesterday, but also in the case law. The picture I choose for the presentation is Polish witness and victim of medical experiments at the Ravensbrück concentration camp, pharmacist Janina Bröll-Platter, one of 3 victims of medical experiments in Ravensbrück that testified in Nuremberg in December 1946. As we know from yesterday's talk, in Nuremberg, all 177 defendants that stood on trial, Nazi high-ranking politicians, industrialists, SS men, and but also military personnel were charged with the charge of crimes against humanity, even though not all of them were convicted for that crime. But this jurisprudence and these tribunals have analyzed this category of crimes and different types of victimization within those organized patterns of violence. To move to the UNWCC contribution, I would like to present you a very short overview of Commission's scope of work and contribution to wartime debates on defining post-war architecture and definitions of international crimes that addressed war crimes, crime of aggression, crimes against humanity, but also rules of individual liability for international crimes, including collective criminality, but also question of immunity, superior orders, and the question how to prosecute. The idea presented, among others, by Belgian representative Marcel de Boer was to apply the principle of universal jurisdiction to also be able to prosecute crimes against civilians from Axis states, mainly committed against German and Austrian Jews. And this was element of the discussion on crimes against humanity, which was driven or enforced by Marcel de Boer, Bohuslav Etter, with his report on crimes against humanity from summer 1944. The scale and systematic nature of Nazi violence and methods applied against civilians was on the focus of Commission's members, And this very early documentation approaches, documentation initiatives from the 1942-1943 that led to defining crimes against humanity, targeting different groups, vulnerable victims, but also cultural heritage as a part of identity of a nation, social or political group. Also defining patterns of organized violence that were to be traced in occupied states. The Commission has produced, within this 5 years of occupation, cases or evidence against over 35,000 of suspects. Well, 36 is the total number, 35 is the total number of German suspects suspected of crimes committed during the war. Those were, of course, not only crimes against humanity, but in these cases we can find many details concerning persecution of different targeted groups. This discussion, concerned the criminality, but also the individual liability for war crimes and individualization of culpability. A topic that was very extensively discussed also among the Polish lawyers even before the Commission was created. The rules for establishment of individual liability in cases of war crimes were presented, or a proposal to define those rules were presented by Polish representative to the Commission, Stefan Glasser, in April 1944. Glasser proposed to address both the responsibility of the person issuing criminal order and the persons executing it. His proposal stipulated the responsibility of all of the officials belonging to the occupation apparatus who issued or signed illegal legislation incompatible with international law or gave orders to commit criminal offenses. The second principle established the individual liability of administrative superiors for acts committed within their districts. The third principle stipulated the guilt of judges for judicial crimes and for adjudicating on the basis of legal provisions violating international law. So this proposal aimed at enabling prosecution of organized state-directed violence. This was also reflected in the definitions of international crimes or proposals to extend the list of crimes under Commission's jurisdiction that were initially the Paris Peace Conference proposal of the Commission of Responsibilities of 1919, the 32 crimes defined back then. Stefan Glasser's idea was to underline two aspects of organized persecution of civilians in occupied territories. The first one was the implementation of discriminatory and degrading procedures and legislation. Glassers provided to support this mention examples of German legislation discriminating against Polish and Jewish people in the occupied territories, such as special criminal laws for Poles and Jews, prohibition from entering public or private buildings, bans on the use of the Polish language in public spaces, stigmatizations of Jews, bans on religion practices. He saw here the violation of basic human rights motivated by the ethnic and cultural identity or membership in a group. In his argumentation, such persecutions constitute an element of policy aimed at destruction of the cultural and spiritual sphere of life of the individual as a member of the community. The second proposal concerned the persecution of political opponents and political groups, the mass arrests of persons included in prescription lists defined as enemies of Nazi ideology, which were not only in Poland, also in Czechoslovakia, a means of everyday terror and persecuting accidentally civilians accused of acting against the Third Reich ideology. This idea of these proposals and idea to extend the catalog war crimes underlined that they constituted planned and systematic activities against civilian population. Glasser stressed that these acts were incompatible with the reasonable administration of occupied territory and violated the preamble of the Hague Convention that was quoted yesterday. Those rules and those aims of underlining and exposing the suffering of civilian populations was also mirrored in the cases presented to the Commission. They considered the persecution of intellectuals, of course, victimization of Jews in concentration camps, ghettos, forced labor camps, but also the organized violence and discrimination by means of law. Here is only one example of those charges against Adolf Hitler and German government concerning the legal discrimination of Jews in occupied Poland, but this was accompanied by several cases concerning organization of justice in occupied territory or activities of the Sondergerichte in Germany against foreign nationals persecuted and convicted to death. All these cases show the systematic violence, inclusion or activities of the judiciary within the Nazi policy aiming at the extermination of, in this case, Jewish population, but in general, targeted groups. Similar argumentation was used in the charges prepared by the Czechoslovak government in 1944. I'm underlining in the dates, very early stage of issuing charges against Nazi criminals. Those concern the legal discriminations, activities of Sondergerichte, but also systematic terrorism and massacres of civilians applied as retaliatory measures in Lidice and Leżaki. And in all those charges listed here, the German government as criminal organization responsible for designing, applying, and executing this policy of persecution is accused. The patterns of violence presented in WCC cases were deeply analyzed in complex cases, which are mostly very extended in cases of concentration camps charges. On these examples concerning the Auschwitz cases from 1944 and early 1945 submitted by the Polish government, I wanted just to list you the targeted groups included here in the indictments, but also show you the scope of the charges and particular elements of those crimes concerning sexual violence against women, but also children. In both of them, the second one is focused on the medical experiments conducted by Josef Mengele and other doctors at Auschwitz. We can find some information on sexual violence, although it's never, in these complex cases, the main charge, but we can find here very precise information about perpetrators or victims. The vulnerable group or women as targeted group are very often, maybe too big exaggeration, but are present in UNWCC cases, and there are even cases devoted slowly to the crimes against women, to the crime of rape, forced prostitution, and of course crimes that affect reproductive rights, those like medical experiments. But by analyzing those cases, we can find a lot of details about victims of gender-based crimes, such as forced pregnancies, forced use of contraception, abortions, restriction of reproductive rights, but also gender persecution, not only against women, also men or minors, or sterilization. Here on the slide you can see one of the first cases, the French one, concerning the deportations from France to concentration camps, but also the enslavement of young girls for the forced prostitution, which is charged that we can find in more cases. And the last example of vulnerable victims and details and particulars of violence against vulnerable group, children and minors, is presented here. And again, extended list of types of persecution and victimization of children that is mirrored in multiple cases, some of them devoted slowly to activities of Lebensborn or deportations for Germanization from Czechoslovakia, Poland, other countries, but also sexual abuses against young girls. So also an important and extensive collection of documentation presenting, capturing the experience of civilians that was not necessarily and not extensively discussed at Nuremberg, neither before the International Military Tribunal nor by the American military tribunals in the Nuremberg subsequent trials. Therefore, I believe those cases and discussions should be included in our considerations about the origins of crimes against humanity and early attempts to prosecute them. Thank you very much for your attention.
Thank you, Dominika. So next speaker is Professor Karolina Wieczyńska, and she will present topic children as targets of crimes against humanity. Professor.
Okay. Mam coś powiedzieć, żeby można było, tak, żeby nie było pogłosu i żeby było wspaniale mnie słychać. Państwo mnie słyszycie wspaniale. Może coś zaśpiewam. O, czemu nie po polsku? Jesteśmy w Polsce.
So you see, we have 21st century, we're using AI, we're prompting AI, but in terms of technology, we use the same microphones like yesterday, and they are not working today. So you see.
Tak mogę zacząć? Czy jeszcze? Okay, thank you very much. When I was preparing today's presentation, I asked Gemini AI to create an image featuring what we commonly recognize as a symbol of a child, a toy, or a piece of clothing. I also requested that the illustration be a negative rather than a standard photograph. Using a negative serves as a visual metaphor for a world turned inside out. Because a crime against humanity is a negative, as it is a radical denial of civilization and the moral order. In a negative, what should be warm and alive becomes cold and ghostly. A bright, almost glowing shoe against a dark background suggests that this object is a ghost, left behind by someone who has vanished. In research on international crimes, the shoe has become one of the most powerful symbols, much like in the museums at Auschwitz or Majdanek, it represents a specific individual who is no longer with us. The fact that the shoe is small immediately directs the viewer's emotions and attention toward the vulnerability of children who became targets of crimes. Victims of the Second World War were to a large extent children, yet when the Nuremberg trials and subsequent national trials began, children were rarely visible as primary victims of the crimes. They appeared in the tribunal's narrative only when it was necessary to strengthen the message, to strengthen this narrative, and demonstrate the gravity of the atrocities committed. At the same time, however, the trials were not focused on specific victims of the war at all. Ladies and gentlemen, today I would like to explore a topic that has long remained at the margins of international criminal law, despite its profound historical significance: children as targets of crimes against humanity. During the war, children, arguably the most vulnerable members of society, were systematically tortured, persecuted, murdered, abducted, yet international criminal proceedings struggled to conceptualize these harms, often subsuming children within the broader category of the civilian population. My presentation traces the evolution of the legal treatment of crimes against children, beginning with the pre-war normative landscape, moving through the International Military Tribunal at Nuremberg, and then the turning to the subsequent trials, particularly the Russia and Einsatzgruppen cases, and finally to the pioneering jurisprudence of the Polish Supreme National Tribunal in the Greiser case. Before the outbreak of the Second World War, the international protection of children rested primarily on moral declarations, not on enforceable legal norms. The 1924 Geneva Declaration on the Rights of the Child proclaimed that child must be protected against every form of exploitation, but it was not any legally binding obligation. There were, however, several binding instruments addressing specific harms, such as 1904 Agreement on the Suppression of the White Slave Traffic and 1921 Convention on the Suppression of the Traffic in Women and Children. And these treaties explicitly mentioned children, yet they did not conceptualize them as a distinct group of victims requiring special protection or special attention. They addressed particular offenses not of broader vulnerability of children in situation of mass violence. So, on the eve of the war, the international community possessed only fragmented tools for addressing crimes against children, but no coherent framework that recognized children as the uniquely targeted group. The United Nations War Crimes Commission documented numerous crimes committed against children, as Dominika Uczkiewicz just mentioned, particularly denationalization, forced re-education, deportations. Reports described children forbidden to use their language, compelled to salute in fascist fashion, or transported to the occupying state for cultural assimilation. Yet even here, children were not treated as a special category. They appeared as a part of general population, not as uniquely targeted victims. This early documentation was crucial, but it did not reshape the legal framework. When the International Military Tribunal was established in 1945, the charter contained no reference to children, nor even to victims more generally, because the IMT was designed as a perpetrator-oriented model, focused on individual criminal responsibility for war crimes, crimes against peace, crimes against humanity. The charter did not articulate victims' rights, nor did it differentiate among categories of victims. During the proceedings, witnesses such as Seweryna Szmaglewska and Samuel Reitzman described in a detail the mass murder of children in Auschwitz and Treblinka. Szmaglewska recalled days when the count of baby carriages remaining after the children had been exterminated totaled up to 1,000. Yet these testimonies did not translate into the legal recognition of children as a distinct category of victims. In the judgment, children appear only in the passing, like, for example, in the phrases such as woman, men, and children. Even when tribunal discussed the kidnapping of racially valuable children, it did so within the broader narrative of Nazi racial policy, not as a separate legal harm. A major obstacle was the nexus requirement in the IMT Charter. We were discussing this yesterday. Crimes against humanity had to be connected to war crimes or crimes against peace. This limitation prevented the tribunal from fully addressing pre-war atrocities and non-military strategies such as forced Germanization, identity erasure, or the systematic abduction of children. So Nuremberg provided the moral shock, but not yet the legal vocabulary needed to articulate the specific nature of crimes against children. A significant shift occurred in the subsequent American military trials conducted under Control Council Law Number 10, which removed the nexus requirement and allowed crimes against humanity to stand as autonomous charges. In the Greifeld case, called the Russia case, concerning the SS Race and Resettlement Main Office and the Lebensborn organization, offered the most detailed judicial examination of crimes targeting children. The indictment covered a wide range of acts, like kidnapping of children deemed racially valuable, forced Germanization, seizing infants from Eastern workers, forced abortions, and so on and so on. And the tribunal convicted several defendants like Greufeld, Kreutz, Lorenz, Brückner, Hoffmann, and so on for their roles in these policies. Their crimes ranged from the prevention of birth to the systematic erasure of identity after birth. But paradoxically, the leaders of Lebensborn were acquitted in Russia trial. And one of them, Ebner, who was convicted later by the Munich denazification tribunal for his role in the Germanization of Czech children from Lidice. This divergence illustrates the evolving understanding of crimes against children in the immediate post-war trials. In the Einsatzgruppen case, the tribunal confronted the mass murder of children more directly. Testimony revealed that children were executed, not merely because they were part of the civilian population, but because they might grow up to oppose the National Socialism, to seek revenge. This chilling rationale shows that children were targeted not for what have they done, but for what they might become. Yet even here, the tribunal did not conceptualize children as a separate legal category. They served primarily as evidence of the totality of the extermination program. To fully understand the post-war landscape, we must look beyond Nuremberg to the jurisprudence of Polish Supreme National Tribunal, which tried major Nazi perpetrators responsible for crimes committed on Polish territory. In the Greiser trial, the tribunal articulated a more nuanced understanding of crimes against children. Arthur Greiser, the governor of the Warthegau, implemented policies aimed at both the biological destruction and the cultural annihilation of the Polish population. His measures included drastic reductions in food rations, removal of legal protection for minors, forced labor of children, systematic destruction of identity and family bonds. The tribunal recognized that children were not incidental victims, but central targets of a genocidal strategy aimed at extinguishing future generation. This recognition marked an important step toward a victim-centered understanding of crimes against humanity. And I think I should make a note that yesterday we were talking about this placing genocide in the broader context of crimes against humanity, because it was the practice at the time. The trajectory from 1924 Geneva Declaration to the post-war trials reveals a gradual but profound shift. Initially, children were invisible in the legal framework, absorbed into the general category of civilian group. Nuremberg, despite its moral force, did not yet articulate the specific harms inflicted on children. It was only through the subsequent trials, Russia, Einsatzgruppen, Greiser trial, that the international community began to understand the full spectrum of crimes committed against children, from murder to extermination, to kidnapping and forced Germanization, to the destruction of identity, culture, and family. These judicial efforts laid the groundwork for the later developments, including the 1989 Convention on the Rights of the Child and 1998 Rome Statute on International Criminal Court, which slowly led to the idea to recognize children as distinct right holders within international criminal law. Today, as we confront contemporary conflicts in which children continue to be targeted, the lessons of these early cases remain urgently relevant, because they remind us that crimes against children are not only merely violations of individual rights, they are attacks on the very continuity of communities and nations. Thank you very much.
Thank you, Professor Wierczyńska. And last but not least, Professor Stefanie Bock with the topic of women as targets of crimes against humanity. Professor Stefanie, the floor is yours.
So do we have my presentation? I have it on an USB stick, if this helps.
Okay, czyli trzeba... tak? Dobrze, przepraszam.
Yeah, this.
Okay.
Good morning, everyone. Please let me first thank the organizers for this timely, important, and inspiring conference. I'm very grateful to be here today and to have the opportunity to share with you my thoughts on a specific, and I would argue still underexplored dimension of crimes against humanity, namely women as target of crimes against humanity. Let me start with a basic question. Why talk about women specifically? As was already indicated by Dominica's great presentation, already at Nuremberg, prosecutors and judges were aware that countless women had become victims of massive and systematic gender-based, sexualized and reproductive violence during the Second World War. On 14 February 1946, to give but one example, the Russian Chief Counselor of Justice Smirnov presented various witness statements testifying that German soldiers, I quote, violated every one of the women and girls, opened a brothel for officers into which hundreds of women and girls were driven, and raped the women and the girls under the very eyes of their kinfolk and children. I could continue for hours. The defense did not even contest these allegations and apparently regarded them as a kind of normal byproduct of wars and armed conflicts. And neither the indictment nor the judgment contains any explicit reference to violence against women, although there would have been a legal avenue to address it at least as another inhuman act. If one reads between the lines of the judgment, it is possible to argue, as in the case of children, that the rapes and other acts of violence against women were implicitly subsumed under the findings of ill treatment of the civilian population. This does not alter the fact, however, that these acts remained effectively invisible in the judgment. Now contrast this with the recent example of the 2024 arrest warrant of the International Criminal Court in the Afghanistan situation directed against senior leaders of the Taliban. It was based for the first time in the court's history entirely on gender-based persecution. The targets of these crimes were women and girls, deprived of education, of movement, of employment, of legal personality, and the right to bodily integrity. In addition, the arrest warrant explicitly recognizes, for the first time in the history of international criminal law, LGBTIQ+ persons as a distinct protected group. Gender perspectives are at the heart of this case. What changed between Nuremberg and this arrest warrant? Not the crimes themselves. Persecution on the basis of gender has existed throughout history. What changed was the legal language, the willingness to name. So, does naming matter? Let me offer 3 reasons. The first is linked to the concept of fair labeling, the principle that offenses should be described and categorized in a way that accurately reflects the nature and gravity of the wrongdoing. When we subsume systematic rape of women or the wholesale exclusion from public life under the generic label of crimes against civilians, we misrepresent the nature of the crime. We obscure the fact that the civilian population is not a homogeneous group. The victims are not targeted randomly, but selectively, because of who they are and what they are perceived to be. Fair labeling is not merely about accurate bookkeeping. It shapes how perpetrators are judged and violent acts are understood, how sentences are calibrated, and how victims are recognized. Secondly, invisibility in law reinforces invisibility in society. When gender-based crimes are absorbed in a general category, the implicit message is that the gender dimension, the fact that women were targeted as women, is legally irrelevant. The sends a signal to survivors, to society, and to future perpetrators alike. Thirdly, recognition and accountability are preconditions for reconciliation. This point is perhaps best illustrated by a painful counterexample. The so-called comfort women, the hundreds and thousands of women, predominantly Korean, who were subjected to systematic sexual slavery by the Japanese Imperial Army during the Second World War. For decades, their suffering was not named as an international crime in any legally binding forum, and the fight for recognition still continues today. Rendering certain types of crimes invisible and withholding justice from entire groups of victims impedes societal processes of coming to terms with the past, and with them the emerge of a peaceful, stable, and inclusive conflict social order. And it's precisely this gap between the reality of gendered violence and its legal recognition that the Afghanistan arrest warrant clearly addresses. It signals that what is happening to women and LGBTIQ+ persons in Afghanistan is not an incidental byproduct of a general repressive regime. The systematic oppression of women is not a feature of the Taliban rule. It is its very foundation. It is a crime in its own right, and that matters. So with a view to the currently discussed Convention of Crimes Against Humanity, the question arises, if we want gender-specific crimes to be included, is what exactly is gender, and should the convention provide a legal definition of gender? The Rome Statute of the ICC defines gender as referring to the two sexes, male and female, within the context of society. This definition attempts to square the circle. It is a deliberately ambitious formula designed to accommodate states that link gender strictly to biology and reject any acknowledgement of non-binary or transgender identities, while at the same time satisfying more progressive views by acknowledging that gender is, at least, also a social construct. In diplomatic terms, this was a success. It got the statute adopted. In legal terms, it has been a persistent source of difficulty. And the tension became visible in the Afghanistan situation itself. The ICC warrant addresses persecution of LGBTIQ+ persons, despite the fact that the Rome Statute's definition of gender refers only to the two sexes. And at least in the policy paper of the crime of gender-based persecution of December 2022, the Office of the Prosecutor has advocated a broad interpretation of the concept of gender, explicitly including LGBTIQ+ persons, and thus persons who fall outside a biologically framed binary conception of sex and gender. The pretrial chamber appears to have followed this approach in its arrest warrant decision. I consider this outcome to be entirely correct, yet the tension with the statutory definition in Article 7 of the Rome Statute cannot easily be resolved. The degree of judicial creativity displayed here by the ICC is readily exposed to the charge of imposing ostensibly Western values through the means of international criminal law and of violating the fundamental principles of legal certainty and forcibility. In this way, the Taliban regard the very acts described in the arrest warrant as not merely permitted, but positively mandated by the Quran, framing them as an expression of religious conviction rather than criminal behavior. And they have characterized the ICC as a neo-colonial instrument of oppression and its arrest warrant as an attack on all devout Muslims. If the Convention is to overcome such problems of interpretation and ensure comprehensive protections for all persons, regardless of their sex, sexual orientation, and gender identity, it must seek a comprehensive and inclusive concept of gender that places the social construction of gender at its center. In this sense, gender might best be understood as a constructed, multidimensional, and multi-relational criterion of differentiation. On the basis of certain physical characteristics, the sexed body, people are characterized and assigned gender-related expectation. These gender norms relate not only to behaviors, but also to different preferences, fields of knowledge, competencies, sexual preferences, and orientation attributed to men, women, and non-binary person. This conceptual richness, however, is precisely what makes its legal definition so difficult. In international criminal law, with its claim to universal applicability, the particular challenge arises that how gender is conceptualized in a specific context, whether in a given society, historical period, legal instrument, or religious text, and the attribution with gender is associated depends on biological, historical, cultural, geographical, social, and economic factors. The resulting dynamism and variability of the concept of gender make it difficult to define with the precision required for a convention. I would therefore tend towards not defining gender in the convention itself, but leaving the concretization of this concept to those applying the law. This also preserves the degree of space to interpret gender in a situation-specific manner and in light of the cultural context that characterizes a particular set of acts. At the same time, and this must be stated as a clear rejoinder to the Taliban's critique, cultural and religious conceptions of gender may not be invoked to legitimize a system of systematic oppression that stands in blatant contradiction to the fundamental human rights principle of the equality of all human beings. The recognition that gender and gender norms may create and legitimize societal systems of inequality brings me to the question whether gender-specific acts already known from the Rome Statute should be supplemented by the crime of gender apartheid. The Rome Statute defines apartheid following the Apartheid Convention of 1973 and inspired by the South African example as inhuman acts committed in the context of an institutionalized regime of systematic oppression and domination by one racial group over any other racial group, and committed with the intention of maintaining that regime. It focused exclusively on the discriminatory criterion of race. Gender apartheid would break open this restriction and extend the crime to cover the oppression of a gender group as well. The appeal of this analogy to the racial apartheid system is clear. What the Taliban have done in Afghanistan and what other regimes do in different degrees elsewhere is not simply a series of discriminatory acts. It is a construction of an entire system, a legal architecture of subordination. Women are excluded from education by law. Their movement requires male guardianship by law. Their testimony in court is worth less than a man's by law. Their employment, their dress, their subordination to husbands and fathers, their very presence in public space, all regulated, restricted, and punished by law. The existing crimes against humanity of sexual violence, inhuman acts, and gender-based persecution can capture individual acts of violence and systematic exclusion. But their focus remains ultimately on individual acts and their consequences. The concept of apartheid adds a structural dimension. It captures the system of oppression, the legal institutionalization of inequality, the deliberate construction of a social order built on hierarchy. However, and this is where I want to push beyond the existing proposals, I think we should be careful about how closely we model gender apartheid on racial apartheid. The South African model was built around a specific concept of race that was itself legally constructed. Races were formally defined, registered, and administered. When we translate this to gender, we risk importing some of the same rigidities. What I want to propose is that we go further and think more carefully about what the core of any apartheid system actually is. It consists, I suggest, of two elements. First, the construction of a system of human differentiation, the selection of a characteristic, whether race, gender, class, or any other marker, and its inscription into a legal and social order as a basis for classifying human beings into groups with different legal standings. And second, the use of that differentiation to build and legitimize a society structured around inequality, one in which the differential treatment of this group is not incidental but constitutive, where one group is systematically denied fundamental rights, and where that denial is legally secured and institutionally enforced. Defined in this way, the new crime of apartheid need not be a mere metaphoric extension of racial apartheid. It can stand as an independent legal concept with its own internal coherence, one that captures not just the suffering or discrimination of individuals, but the construction of a system designed to subordinate an entire group. Everything I've argued so far, the importance of naming gender-based persecution, the need for definitional clarity on gender, the utility of a gender or broader apartheid framework has been framed primarily around women. And this is appropriate. Women are particularly vulnerable in violent conflicts. They are the primary targets of gender-based persecution in most documented cases, as the Nuremberg record itself, read between the lines, already attests, and the legal framework must be capable of capturing that reality. But I want to suggest that if we build these concepts correctly, if we define apartheid in terms of the structural construction of hierarchies, rather than in terms of any specific protected group, we have also to build a framework that is, in principle, intersectional in its reach. Understanding intersectionally not as a metaphor, but as an analytic tool for international criminal law, allows us to see how axes of oppression, gender, race, ethnicity, religion, class, sexuality, do not operate in isolation, but interlock to product-specific, compound, and at times uniquely severe forms of violence. The prosecution of the Yazidis by the so-called Islamic states illustrates this with particular clarity. The Yazidis were stigmatized by the IS as an infidel religious minority, systematically disposed, displaced, and killed. The practices of violence, however, were differentiated along lines of gender and age. Men and older women frequently fell victim to massacres or forced conversion. Boys were indoctrinated on a large scale and forcibly recruited for armed combat, while young women and girls in particular were subjected to sexual violence, enslavement, and forced marriage. This collective persecution was not the product of isolated discriminatory factors, but of a structural interlocking system of multiple axes of oppression. Religious stigmatization legitimized violence against the Yazidis, who were constructed as an outgroup through processes of ethnic othering. At the same time, the bodies of women and girls were rendered spoils of war through gender-specific attributions. The sexual violence directed against them served not only to subjugate individuals, but was aimed at the destruction of the Yazidi community as a social, cultural, and religious collective. This example shows that gender-based persecution and gender apartheid are not merely women's issues. There are entry points into a broader structural analysis, one that international criminal law has so far only begun to develop. The new Convention on Crimes Against Humanity offers not only the opportunity to strengthen the rights of women. The individual acts of persecution and apartheid, properly defined, open a pathway of embedding intersectional perspectives more firmly in public international law and international criminal law alike. We should seize it. Thank you very much for your attention.
Thank you so much. So we'll switch. Is it working? Maybe I use this microphone for a while. I just wanted to, before I open the discussion, I just wanted to bring to attention the Lemke Center, which is working at the Pilecki Instytut. Since 2022, because we released 2 reports about sexual violence. I mean, one report about sexual violence and one report about violence against children. And you can collect the reports. They are at the reception to take. So if you're interested, please do so. So there are very important topics. Is it working? Yes, Joa? Okay, it should be working. Yeah, it's working. Thank you so much. So I'm opening the discussion. We have 10 minutes for the discussion, more or less, before the coffee break. So please, do you have any questions? Okay, I think Professor Heller was first. Kevin, please.
Thanks. Great panel. I have 2 short questions, one for Dominika and one for Dominika and Stephanie. The first one is, I would just be curious to hear your assessment of the quality of fact-finding from the UNWCC. 36,000 suspects in 5 years is an awful lot, and as we know, Taylor's office struggled to do 500 in probably 3 years. And then the broader question is, to both of you, what do we actually know about why rape was included as a crime against humanity in Law Number 10 when it wasn't included in the London Charter? And what did they hope to accomplish by including it? Obviously, it didn't lead to whatever they might have hoped, but I don't even know what the thought process was behind specifically including that. So if either of you have any insights into that, it would be most appreciated. Thanks.
Okay, so let's collect the questions and then answer. Yeah.
Yeah, thank you very much for the panel. So I have one question to Dominika. So you mentioned this concept, capitis diminutiae, I think, which was brought up by Manfred Lachs. I mean, the Roman concept of civil death. And yeah, basically my question is whether you know anything about the development of this concept. I mean, was this in a way used for the development of crimes against humanity, and if so, in which way? And my other question is to Stephanie. Maybe it's a little bit far-fetched, but basically I don't understand why. I mean, you have demonstrated right now this elaborated jurisdiction. So why are Yazidi women? Why they don't get protection in the context of refugee asylum law? Because nowadays they get deported from Germany, and I simply don't get it. Yeah.
Thank you. I have a question for Professor Bach. When reading the draft convention on crimes against humanity, like you, I also recognized limitations in the apartheid clause. What about expanding the definition, not just for racial-based apartheid and for gender-based apartheid, but including ethnic, indigenous versus non-indigenous, etc.? I mean, I think overall it's a very problematic and old definition in this convention. And if we're really discussing systems of legal differentiation and mistreatment, don't we need an even broader definition or really an entire rethink of the concept? Thank you.
Okay, any other questions? Here, 2 questions, please. Yeah.
Thanks for the really interesting panel, and I thought it was really also well shown that there are specific characteristics of children as a group or women as a group. But horizontal question, the draft as it speaks now, it just speaks about persecution of any identifiable group without starting to list the different groups. My question now, if we start to list the specific groups, that should be fall under this category. Do we not risk to miss a group? And then at once, by starting to list specific groups, we end up by omitting the listing of a specific group, and then the protection wouldn't be given anymore. So what is the added, by identifying certain specific groups, is there not only the risk of excluding other groups, but at the same time, will we make certain crimes additional, be part of the definition or not?
Okay, and the last question from Patricia, and then we will answer.
I have a series of questions, but I try to be short. First question to Professor Wierczyńska. You presented why and in what context the children were present in Nuremberg proceedings, but I had an impression that you said that well, firstly, if we look why children were presented in Nuremberg judgment, it was just to show how egregious the crimes were, how brutal the war was. So it was just exemplary, I would say. And then you also explained that children were, in this aspect that they would grow as the future nation. It sounds rather like genocide, not as a crime against humanity. So my question would be that, having in mind this Nuremberg lesson, is it really worth to indicating children as specific group within now within contemporary negotiations, or maybe we just missed the point that children were pointed out to prove genocide a specific crime against humanity. And I have the follow question to Mr. Franz Perez. You did mention, Stephanie, apartheid, including gender apartheid. And my question would be whether we really need to expand the definition of apartheid, or we can just stick to persecution and we would achieve exactly the same result. And when you did stress rightly to the ambiguity of the definition of gender in the Rome Statute, do you consider that maybe to be more precise doesn't mean to be more inclusive, but rather to stick to biological sexes, which would be much more acceptable for many states than to have this ambiguous definition which we have now? Thank you.
Okay, so please, Stephanie.
Okay, I go first, and I try to remember everything. Inclusion of rape. I think Domenica can say much more about this than I do, but it was at the same time where we got sexual violence more and more recognized as a war crime, and we have included, not as a war crime, but at least we have included the protection of women and the protection of women from sexual assault in the Geneva Convention. So I think there was this dynamic between what you already mentioned yesterday, this dynamic between the laws of war and crimes against humanity, and I think this is another example. I think this question I'll link, Pat. I think we need apartheid because it covers a different, more structural dimension than persecution. Apartheid really points to the fact that we have created a whole system, a whole legal system based on hierarchy and oppression, and this is in addition to persecution. And in the context of fair labeling, I really like this concept of apartheid. And yes, I would say we must be broader. We must not present an exclusive closed list of criteria of human differentiation. We can stick to the classical example of race, gender, whatever, but this should not be a closed list. We must be flexible, and we must be flexible enough to incorporate this intersectional perspective and say, here we have a combination of different criteria. Here is the specific vulnerability, the results of a differential treatment based on two axes of discrimination. And so open definition, no exclusive list. And the definition of gender, I know it's very hard to advocate for such a broad definition. So I would say silence of the convention. Don't define gender as all, and every state is happy and say, okay, gender, of course, it's only linked to the two sexes and it's a biological concept, what else? And the other states say, okay, of course, gender is social construction, and then we leave it open. The problem is that we in the Rome Statute now have is that this definition doesn't work because it tries to combine biology and social construction, and this does not fit together easily. And we have the extension, at least in the work of the prosecutor, very clear to include LGBTIQ plus person with a view to this definition is not easily aligned with the Rome Statute. So I said, silence on this issue, leave it to those who are applying the law. Okay, I hope I covered everything.
Karolina?
I would like to first to refer to the question of Mark Lewis. I know you didn't address me, but anyway, I have something to say. I was taking part in the preparatory committee in January on the Convention on Crimes Against Humanity, and what I learned is that some states, they are really stuck to the rule, to the principle of legality, and they want to mention as many criteria as it is possible in the name of the principle of legality. If you talk about gender apartheid or some ethnic characterization or indigenous group, they just want to put it all into the convention just in the name of principle of legality, because it will be written, so it, you know, in this positivist way, it will be lex certa. And this is how I understood some struggles of states. Referring to the question of Professor Perez, you ask if we list the group, don't we miss the other groups, the other protected groups? And it is actually linked to the question of Patrycja Grzebek, so it will be one answer from me, if I understood you well. I think that we should identify all those missing groups because they need the special treatment. In a way, they just need a special treatment, like children, like women, like LGTB, like disabled people, and those groups are identified for many decades now. So they are not any novelty, that they just need a special treatment, and that is why some states are struggling to include those groups into the convention. Poland, for example, has children on its agenda, and we really think that we need to include some specific regulations concerning the rights of children. Thank you.
All your questions. Professor Heller, if you do not have the answer to these questions, which I was supposed to ask you yesterday, I will not allow myself to give the ultimate answer. I suppose the documentation of sexual violence, acts of rapes was evident and massive. That may be the reason for including this crime into control conceal law definition. As we know, the program for subsequent trials was developing, was dynamic and more extensive at the beginning, and the outcome was limited. But whether there were plans to prosecute rape, let's discuss it based on research. I do not have answer to these questions, but I'm also very, very curious. But it's evident gap and omission, especially facing those cases from UNWCC that collected documentation provided by the member states. It was not a centralized documentation model, but much more institution providing support for coordinating documentation, but also unifying the methods of evaluating evidence, also identifying victims. So I believe the quality of those charges or cases is also very different, and from very detailed and well-prepared, documented and covered by extensive evidence cases with details of personals of, concentration camp members or some Einsatzgruppen members who are identified by name or additional characteristics, to vague and not that precise documents. Of course, misspellings in the names or wrong names of different soldiers, mixing up the ranks of the perpetrators. This kind of mistakes do appear there, make this evidence or at least personal data of alleged perpetrators less useful or unuseful, but still contextual details of crimes are very important. In some cases, we do not have any details on the perpetrator, well, any personal details. I would assess, I would give positive assessment to this whole collection, and 35 or 6,000 names of alleged perpetrators from all Axis countries does not seem that big number. I believe it only shows the attempt to identify the suspects, which was also possible thanks to not only central administration or offices, but resistant movement, society under occupation. That's a very important source of information that was gathered. Professor Weinke, thank you very much for mentioning Manfred Lachs, who was in charge and chair of the Jewish section of Polish War Crimes Office. So each UNWCC member was supposed to create respective war crimes office, so this national agency responsible for preparing documents for the commission, but first of all documenting the crimes. The polls have started before the commission was created in 1940, and afterwards a special section dealing only with crimes against Jews was created. And then within the commission structure, Manfred Lachs was in charge of this section, preparing those cases devoted to anti-Jewish persecutions and crimes. And so far I know it is the only case where this Roman civil law concept of capitis diminutio maxima is mentioned. So like civil death or becoming homo sacer, the person excluded from the community, denied any legal status was applies. I believe as exemplification of this situation of exceptional situation of Jews, and also this very technical mean of exterminating a group on paper within legal terms, means, and before entering to the next stage, which was physical extermination. And this charge is very interesting. I'm always hoping to find time to read it more carefully and write something more about it, as it refers to so many legal concepts and legal philosophy notions. It's very interesting, but mostly referring to human rights, principles of humanity and rights of civilized nation as the principles to be protected. And I believe with this comment, I will stop answering to those questions. Thank you for our comments and questions to our panel.
I have forgotten your question. I'm so sorry. I've forgotten it because I can only say I don't know. It was about the migration situation, asylum situation of Yazidi women. I guess it's a combination. We have legal loopholes in the standalone protection of women, in particular married women, when it comes to gender-based persecution. So the legal law is not very clear on this issue. And the other point will probably be connected to the question, which countries do we recognize as safe, which may be a different category to the question which countries are actually safe.
Okay, thank you so much. And I think we have to close the discussion. We all deserved a coffee break. And I would like to thank you all for participating, and see you in 15 minutes.
ladies and gentlemen, our break has met its end, and I'm honored to be chair of our next panel. My name is Bartłomiej Kapica, and I'm the head of the Center for Totalitarian Studies here at the Pilecki Institute. And in the forthcoming panel, we are going to present different phases of the crime against humanity. We have distinguished speakers with us. Unfortunately, one of them, Dr. Amina Adnan, couldn't make it due to the personal reasons, and she will join us online. And Amina is our first speaker. Is she online right now, available? Or yeah? Okay. Okay. Hello. And so let me present you Amina, who is going to talk about slavery and forced labor. Dr. Amina Adnan is a lecturer and assistant professor in law at Maynooth University, National University of Ireland, specializing in international law and human rights. Her primary research areas are universal jurisdiction and the history of international criminal law. She analyzes the evolution of international criminal law, specifically the prosecution of atrocity crimes in national courts. Amina, you have unfortunately only 15 minutes, but I hope it's going to be okay. The floor is yours.
Thank you very much. Thank you very much, Bartek. Good morning, everybody. I hope everybody can see my slides. Yes. Wonderful. Great. Thank you so much to the Pilecki Institute, to Patricia and Domeka for the opportunity to present at this timely and important conference on crimes against humanity. It's a privilege to speak alongside such distinguished speakers and guests, and my apologies that I cannot attend this wonderful event in person. So for this presentation, I'm going to focus on two aspects of the roots of crimes against humanity, that of slavery and forced labor. Slavery, as you're all aware, is universally recognized as an abhorrent crime that is reflective of the worst forms of human suffering. And this has been the case for a very, very long time. It encompasses a wide array of acts, including trafficking in persons for the purposes of exploitation, ownership of persons as chattel or property, debt, bondage, and forced labor. The definition of slavery that we use today in international law comes from the 1926 Slavery Convention, which denotes slavery as the exercise of all powers attaching to the rights of ownership over a person. And we see this language mirrored in the definition of enslavement as a crime, as a form of crime against humanity in the Draft Convention on Crimes Against Humanity, which of course borrows from the text of Article 7 to C of the Rome Statute. Today, slavery is universally recognised as a jus cogens crime, and it engages erga omnes responsibility on the part of states as well. So for this presentation, and in the interest of time, I've selected two case studies that I'm going to go into a bit more detail on, to illustrate the suppression and prohibitions that have applied to this crime for hundreds of years. And that is the attempts to suppress the slave trade from the 19th century onwards, and then the prohibition of force or restrictions on forced labor in international law. So moving on to the first of these case studies, so in its quest for abolition, at the beginning of the 19th century, Britain, for a number of strategic reasons, began its policy of abolishing the slave trade. Now, Efforts on the part of Britain started really from the late 17th century onwards, but really gained ground and became more expansive in the 19th century. Of course, before that, slavery in the context of the African slavery was widely accepted as a means of economic progress. And through the Atlantic slave trade from the 16th to the 19th century, approximately 11 to 12 million people from the African continent were sold into slavery in exchange for goods and money and transported by sea to Europe, the Americas, the Indian Ocean basin. And it was a time where slavery was rife throughout the world. In terms of efforts to legally suppress the trade, there were a number of mechanisms that states took upon themselves to do so, and one of those was the right of search, visit and seizure over suspect slave vessels on the seas. Now this was a maritime right that belonged to the warships of states or the naval vessels of states, whereby if a naval vessel came upon a suspect slaver, either a vessel that may have slaves on board or have been kitted out for the purposes of slavery, i.e. on its way to collect slaves in a part of the world, that naval vessel had the right to search the ship, inspect its papers of registration, visit the ship, embark on it, and if the suspicion was well founded, they would seize the vessel, its contents and its crew, and bring it to a court of admiralty for adjudication as to whether the capture was legal or not. Now it's important to note that these cases were not criminal in the modern sense, they were prize cases, prize courts, and ultimately considered the question of whether the capture of property had been legal or not. So during the Napoleonic Wars, the British Admiralty, the British Navy were able to rely on a belligerent right of search of commercial vessels of ships during war, and that was based on basically a right of war at that time. And during wartime, that belligerent right was permitted, and it applied also to the slave trade. However, with the end of the Napoleonic Wars, things became a lot more difficult, and it was harder to legitimately exercise this right because, of course, at that time you had the principle of equality of states that applied to states, the community of states at that time, and it prohibited the naval vessels of other states from interfering in what was the legitimate trade of other states. And this is evident in cases such as Le Louis, which involved a French slave vessel that was apprehended off the coast of West Africa, and also the case of a Swedish slaver in the Diana. So as you can imagine, not all states supported this move. The prohibition of warships exercising visitation rights in times of peace was highly interfered with the commerce of which was permitted commerce from other states, and it also drove up insurance costs for states that were still engaging in the trade. Another way that the slave trade was suppressed during the 19th century was through the creation of a network of bilateral treaties, again that Britain used as part of its abolition policy, and it created these bilateral treaties with many other European states, and in effect they established the permission of this exercise of right of search, visit and seizure in particular geographic areas around the world on the seas, and they established these mixed tribunals. whereby the judges of these mixed commissions or tribunals were composed of the nationals of the bilateral treaties, and they adjudicated the legitimacy of captures on the seas. And again, these were prize courts. They weren't they weren't criminal courts in the modern sense of the way. Professor Jennifer S. Martinez in the States, and also Dr. Emily Haslem in Loughborough University in the UK have done extensive research on these mixed commissions, which is worth reading. Yesterday we heard from Professor Metro about the first usages of the term crimes against humanity as it applied to the slave trade from the early 19th century onwards. And you see this sort of language of humanity in these bilateral treaties. So, for example, the 1814 treaty between Britain and Spain talks of the injustice and inhumanity of traffic in slaves and makes multiple references to the cause of humanity. These bilateral treaties, which established mixed commissions, were formed between European states on the basis of a mutual right of search, visit and seizure over each other's commercial vessels involved in the slave trade. However, there were unequal treaties that were also established between Britain and other countries. Nowadays they're called quasi-states, so those states such as in the Gulf, in Asia, that they weren't afforded full state status in the community of nations at that time. And those treaties reflect a non-mutual right of search and visit. Instead, they have an unequal right of search, whereby it was the British Navy that exercised that right over the particular geographical area in the global south. So also in the 19th century, we have the start of a series of multilateral treaties that suppressed the slave trade, beginning in 1815 with the Declaration for the Abolition of the Slave Trade, which was created at the Congress of Vienna, and it pronounced the slave trade to be repugnant to the principles of humanity and universal morality. Then in 1841, we have another treaty suppressing the African slave trade between Austria, Hungary, Prussia and Russia, and that talks about prohibiting the slave trade by prohibiting their nationals and from engaging in the state, and also prohibiting registration of vessels using their flag, engaging in the slave trade. At the latter end of the 19th century, we have the 1890 General Act of Brussels, where a large number of states agreed to a mutual right of search, visit and seizure over suspect slave vessels in particular geographical areas in the world. Then significantly in 1926, we have the creation of the Slavery Convention, and that includes, first of all, a definition of slavery and related practices, and it talks about how the state parties agree to bring about the progressive end to the trade and to related practices in all its forms. Two of the most controversial negotiating points for that convention were the provisions that related to the slave trade at sea and also forced labour. And there were particular reasons for that. Jean Alain, a professor in Monash University, has an excellent text on the travaux preparatoires of the treaty, and he goes through it in very extensive detail. And he notes that ultimately the treaty, as it was negotiated through the League of Nations framework, it has this tension between nations of the global north and nations of the global south in terms of slavery and how the role of slavery in the civilizing mission, which was still ongoing at that time. Notwithstanding these concerns, it still was a very big commitment, this treaty, to progressively abolishing slavery in all its forms. And significantly, it included provisions on mutual assistance in the commitment to prohibit and abolish the trade, and also it included provisions where states were to punish slavery domestically in their own systems. Really important to note as well the role of international lawyers at this period in advancing the prohibition of slavery in the wider framework of or assertions of these crimes known as delicta iuris gentium, or crimes against the law of mankind. And we see this in the writings of reputable and important legal scholars at that time, so the likes of Vespasian V. Pella, Henri Dondieu de Vabre, who later went on to be the French judge at the IMT at Nuremberg, Emile Rappaport. Notably, at the first conference for the unification of penal law in Warsaw, which took place in Warsaw in 1927, the members included trafficking of women and children and the trade in slaves. Included in this list of crimes that they asserted were crimes against the law of nations. And at the fifth conference for the unification of penal law that took place in 1933 in Madrid, Raphael Lemkin added to that list acts of barbarity, which of course was an early wording phrase for what later became the crime of genocide. So turning to forced labour, the history of forced labour is very prevalent in the context of war, and very much linked to the crime of deportation in the context of deportation of a civilian population for the purposes of engaging in a war effort. And also there's a big connection in terms of efforts to suppress forced labour pre-Nuremberg precedent in relation to forced labour of prisoners of war during armed conflict. And we see this in some of the provisions of the Hague regulations from 1899 and 1907, which specifically don't prohibit the use of forced labour, but say that it should be regulated, it should not be excessive, and also that POWs should not be should not be used for forced labour in the context of military operations. Of course, those provisions were heavily abused during the First and Second World Wars. The 1926 Slavery Convention, specifically Article 5, restricts the use of forced labour. And again, here it's not quite banning it, but it's saying that it should be restricted, it should not be excessive, and also that it can be exacted for public purposes. So it's not the case that it was particularly banned, but that it was regulated and obviously should not be excessive. Because the issue of forced labour was so controversial during the negotiating history of the 1926 Slavery Convention, at the League of Nations, after the convention was created, a declaration was passed, or an action was passed by the members to move the issue of forced labour to be dealt with by the International Labour Organization, and that resulted in many actions taken in the context of international labour law in the area of forced labour, and some of which those conventions still apply today. So moving on to the...
Unfortunately, Amina, the time is running out, and could you please go directly into the conclusions?
Yes, I will, of course, thank you. So just to, I suppose, to connect prohibitions on the slave trade and forced labour to the crime of enslavement as a crime against humanity. Obviously, we see the first inclusion of enslavement as a crime against humanity in the IMT Charter itself, and it distinguishes between the war crime of deportation to slave labour and also and then enslavement as a crime against humanity. It was mentioned yesterday by Professor Heller that unfortunately the IMT judgment doesn't go into detail in terms of definitions or the meaning or the elements of crimes. So just to reiterate that in the context of slavery. And just to finish on the point, I want to finish on the point of referring to the Pole case, which was a national case that took place in the U.S. National Military Tribunal that addressed mass forced labour. And there, the judgment talks about the freedom of man from enslavement by his fellow men as one of the fundamental concepts of civilization. And there is a particular paragraph that has been cited in modern ICTY case law, in particular in the Kunarak judgment, which addressed enslavement as a crime against humanity. And there, the ICTY specifically referred to the Paul case, a paragraph that talks about slavery as basically control over another human being, and it being part of and citing the Pull case as evidence of customary international law in this area. So I'm going to stop there, and apologies for going over the time allocated. I look forward to the discussion and questions afterwards. Thank you.
Thank you very much, Amina. And now we can move on to our next speaker, who is going to be Professor Aleksander Gubrynowicz, who is a professor at the Department of Law and Administration at the University of Warsaw. And his research areas are international law, environmental law, and contemporary processes in the East Central Europe. Professor, floor is yours.
Thanks a lot. I will do my best to be as quick as possible only to catch up with the time. But first of all, I would like to express my gratitude for the kind invitation, and I would like to extend my heartfelt congratulations and thanks to all organizers, notably Pilecki's Institute and Patricia Grzebik and her team for making this event possible, so to speak. Ladies and gentlemen, I'm here to discuss the issue of deportation, and the goal of this presentation is to make you familiar with the evolution. So the basic question I would like to answer with this presentation is how it could have been possible to see a deportation, originally classified as a violation of the laws and customs of war, a part or a form of conduct of CIS, crimes against humanities. And of course, the special emphasis in my presentation is put on the issue to what extent the Nuremberg Tribunal was able to delineate, to make a borderline between deportation as a war crime and the deportation as a crime against humanity, because it was a very complicated story, and I will discuss this problem in a later. This presentation is strictly historical, offers a strictly historical perspective, so I don't want to encroach upon the contemporary issues. The contributions of the Yugoslavia Tribunal are deliberately omitted. Having said that, I start the presentation. Okay, so. So the first part, the roots of the deportation. To understand the roots of the issue, we need to go to the 1907, to the Hague Regulation. In Hague Regulation, we can find Article 52, which in essence says that the requisition in kind and services shall not be demanded from the municipalities or inhabitants except the needs of the enemy of the army of occupation. They shall be in proportion to the resources of the country and of such nature as not to involve the inhabitants in the obligation of taking part in military operations against their own
country. Now the question is, what are the limits of this provision? And this problem was of crucial importance during the First World War. But please don't forget that this provision does not prohibit the deportation as an international crime, and of course did not try to define the term deportation. However, in 1916, the famous Belgian concentration, the famous Belgian workers' case took place. In essence, the story was that during the occupations of Belgium, more than 60,000, between 60,000 and 120,000 of Belgian citizens were forcibly transferred to Germany, and that created the general outcry, because not only Belgian but also French government was persuaded that this kind of deportation without prior consent under the coercion should be considered as a serious violation of wars, of the laws and customs of war. And this is exactly what happened at the end of the works of the Commission on the Responsibility of the Authors of the War and the Enforcement of Penalties. And this commission proposed to include deportation of civilians as a future violation of the laws and customs of war. To be noted, at this stage, the term war crime was not as widely used to be the core reference point for the emerging system of the international criminal law. The Commission deliberately omitted the use of the war crime the term as a perhaps premature. What about the reaction of the legal academia? The legal academia was divided. Needless to say, the Belgian scholars were adamantly in favor of the inclusion of deportation to the catalogue of the future crimes prosecuted under international law. But this man, I mean Lasse Oppenheim, was rather cautious, not to say skeptical. He said, well, perhaps deportation should be treated as a crime, but not in every case. He was clearly hesitating in the issue, and let me be very clear at the point. Deportation was out of scope of main concerns of the legal scholars during the interwar period. Some people say that perhaps Sir Hersch Lauterpacht contributed before the Second World War. Basically, it is not true. He contributed to our understanding of deportation during and after the Second World War. But before the Second World War, it could not have happened. And the reason is pretty simple. During the Leipzig trial, deportations were almost not discussed at all. But it should be underlined, however, that during this time, seeing that the efforts to persuade German prosecutors to embark upon the topic failed, Belgian domestic courts passed some sentences to the effect in absentia judgments, okay? So this is... and of course, please don't forget, it is my personal opinion that it is not possible to say that deportations were considered by international law in the interwar period as something which is prohibited under international law, as international law stood at this moment. More than that, we should never forget that some deportations were even supervised by the League of Nations. Let's have an example of the famous Greek-Turkish population exchange agreement. This was perfectly legal in the sense of the international law. Some issues are even more controversial. Consider, for example, the famous Umsiedlung, so perhaps repatriation of Germans from Baltic states. Here the problem is of different kind. To what extent coercion is necessary to classify the transfer of population illegal under the the term of the international law. By the way, the Germans during the discussions at the turn of 20s were of opinion that some Belgians decided voluntarily to get Germany, which was basically not true, simply because indeed they were unemployed, but the unemployment was the byproduct of the deliberate German policy in occupied Belgium. So that's the problem. Okay, so now we are going to the summarize. This is the slide is an attempt to sum up the interwar period. And one thing is absolutely certain: as the deportation were considered legal, it is not possible to say that deportation was considered strictly as a war crime. However, the legacy of the Belgian case was visible. So it is quite interesting to observe that some governments preferred to classify the transfer of population not as deportations, but they were using different label: repatriation, evacuation, expulsion sometimes. But it would be very difficult to say that in 1939 we can clearly establish the borderline between these terms. That's this goes with the same. Now we are after the outbreak of the hostility, after the outbreak of the Second World War, we have the problem which may be summarized as following. So on the one hand, the legacy of the Belgian forced labor case played a very important role in our understanding of deportation. Deportation is still understood as something which is strictly connected rather with the emerging war crimes concept, not necessarily as a crimes against humanity. By the way, the crimes against humanity as a term emerged in 1945. Now, what is the effect? The effect is that deportation is mentioned as a form of conduct not only in the Article 6b of the ITM statute, but also under the Article 6c of the same statute. That is, deportation may be classified as a war crime and a crime against humanity. And now the question is how the IMT delineated between the two. Frankly speaking, it was a tricky question for the tribunal because when you look carefully, the deportations has always been, almost always, not in every case, but almost in every case, were handled under the common heading war crimes and crimes against humanity. So when you have a case of a statistical defendant of which was sitting on the bench of the accused before the Nuremberg tribunal, deportations were discussed under the common heading. Now, of course, another problem. When you look at the first part of the judgment, where the Nazi policies are described, so this part where the story is told about the ill treatment of POWs, forced slave labor program, persecution of Jews, other kind of other parts of the Nazi policy, you must come to the conclusion that deportation is most commonly quoted as a problem in the context of the slave labor policy and only once mentioned in the context of the persecution of Jews. It is perhaps shocking, it is perhaps not understandable, but the fact is that that deportation is localized principally with is attached principally with the problem of slave labor, not necessarily persecution of Jews. Of course, how the tribunal operated. They discussed these Nazi policies, then they discussed the deeds of a particular defendant, and now attention please, they failed or they didn't want to create a sort of definition of deportation. That's truly a problem, because, you know, when if they created a definition of deportation, then they could establish a set of elements which must be cumulatively met so that somebody could be held responsible for the deportation. However, it was not the case of the Nuremberg Tribunal. What they did may be summarized as follows: they analyzed the facts, and then they concluded that the guy X or defendant Y must be sentenced for crimes against humanity and war crimes. And now think how to subordinate, what kind of subsumption was made, what was the role of the deportation in such a context. That was very unclear, and of course it blurred the division line between deportation understood as a war crime and crimes against humanity. However, it would be a big mistake that the tribunal was blind. The case Arthur says Inkart is definitely a proof that IMT tribunal understood that deportation may serve different purposes. So he was sentenced to death, but the tribunal delineated clearly that some deportations for which he was held responsible are strictly within the context of the slave labor policy, and there is another story for which he was held responsible, the deportations of Jews to Auschwitz, and here it is definitely a clear-cut proof that they understood that these two kinds of deportations may not be assimilated or treated on equal foot, so to speak. However, if you look at the next cases, the story is more complicated, because when you look at the Baldur von Schirach, okay, here the story is pretty clear, because he was sentenced solely because of the crimes against humanity, so he was not sentenced for war crimes. Then his responsibility for the deportation of Jews from Vienna clearly falls within the scope of the crimes against humanity. However, if it is about Kaltenbrunner, if it is about Streicher or Frick, the story gets a bit more complicated. But at the end of the day, to make the long story short and not to abuse the time, I'm inclined to believe that here the deportation was classified as a crimes against humanity as well. Now, but however, if you look at such cases like Ribbentrop, Sauckel, here, yeah, Frank, and underestimated case Sperr, the story got terribly complicated, because when you look at the defendant Frank, of course, is described as a war criminal and criminal against humanity. But on the other hand, Frank was not in the part considering Frank. IMT failed to mention his role in deportation of Jews. So he was responsible for persecution of Jews, but not deportation. The deportation is deliberately omitted from his case. If it is about Sauckel, the story is even more complicated, because the guy is principally responsible for the management of slave labor, and all the deeds described in the judgments are strictly connected with his role. But on the other hand, he was sentenced for not only for war crimes, but also for crimes against humanity. And now, what is the general conclusion from all this? First of all, the tribunal had to work with broad, partially overlapping categories rather than sharply delineated offenses. In practice, this led to a functional and context-driven approach in the judgment. There are strong arguments in support of the thesis that Nuremberg judges understood deportations connected with forced labor in occupied territories and should be treated as war crimes, whereas those forming part of systematic persecution, particularly on racial or political grounds, should be framed as crimes against humanity. In practice, however, they follow this line of reasoning very inconsequently, blurring the border lines between the two. That's the general. Why this ambiguities? Of course, nexus. It is one reason, but the nexus is going to be discussed by Professor Olympia, so I omit this from. Belgium deportation's legacy is also a factor which must be taken into account why they didn't want to establish the clear borderline. But I think that there are at least two factors which must be taken into account whenever we are discussing the results. Results which were disappointing. Let me be very clear the point. The UNWCC clearly, as stated in its seminal book, The History of the UNWCC, that if it is about the deportation, there is a clear lacuna in the reasoning of the tribunal. Now, the first additional factor I would like to draw attention is the conditions of deportations. If you have the story of a man who is transported but starved or passed away during the transport because of the conditions, such a situation may be classified as war crime, but may be also classified as what? Crime against humanity. If you have, for example, another problem, final solution factor, we know very well that the lion's share of Jews were exterminated as soon as possible only. But when you look at the passage of the IMT tribunal, discussing the policy of persecution against Jews, you can find the statement which is the following. The methods of Rowno and Dubno, of which the German engineer Grabe spoke, were examples of the one method, the systematic extermination of Jews in connection with camps, in concentration camps, was another. Part of the final solution was the gathering of Jews from all German-occupied Europe in concentration camp. Their physical condition was the test of life or death. All who were fit to work were used as slave laborers in the concentration camp. All who were not fit to work were destroyed in gas chambers and their bodies burned. Against this factual backdrop, it is easy to understand why very often the tribunal had to classify the deportation not under one heading but rather two headings, as a crime against humanity and the crimes against or war crime. Well, so the general conclusion on the issue of the deportation in IMT judgment may be summarized as follows. The definitional looseness produced a degree of conceptual overlap. The same conduct could fall under both categories. Still, the tribunal did not see this as a particularly problematic. Rather than clarifying boundaries, the judgment effectively reinforced the dual qualification of deportation. At the same time, the lack of precision limited the doctrinal development. The IMT reasoning remained case-specific and descriptive, offering lead in the way of the stable legal test. Now, perhaps because I'm off the limit of my time, what about the post-Nuremberg trials? Were they able to stabilize the legal doctrine or offer clearly cut tests? The answer is simple, no. Simply because this Nuremberg trials were performed on the basis of many different domestic legal texts. These domestic legal laws, retributive laws, so-called, varied from one country to another. However, one thing is absolutely certain. Some of them were very close to classify the deportation as a persecution policy element rather, and it was the Polish Supreme National Court, and it is a good occasion to Supreme National Court, and this is a good occasion to underline this element in this room. If it is about other courts, the practice is mixed at best. And finally, we should never forget that, sorry to say, deportation, even after the Second World War, was not considered as a strictly prohibited political act. We know very well that deportations were used by the governments in the 40s and 50s, and nobody could see here as a particularly problematic. Concluding remark. notwithstanding, but what is the legacy of this time? Notwithstanding certain evidence shortcomings, primarily resulting from the absence of a clear definition of deportation, some achievements of the International Military Tribunal, and to a lesser extent of the subsequent jurisprudence preceding the establishment of the ICTY, have proven enduring. And in particular, this includes the recognition that under certain circumstances, deportation understood as the forcible transfer of population carried out under coercion and without the consent of those deported, constituting an element of systematic persecution, may amount to a crime against humanity for which an individual may be held criminally responsible. Thanks a lot for your patience.
Thank you very much, Professor. And our next speaker is Professor Olympia Peku from University of Nottingham, who is a professor of public international law and head of the School of Law. She also heads the International Criminal Justice Unit at the University of Nottingham Human Rights Law Center. Her research interests are in the fields of international criminal law and justice, in conflict and post-conflict capacity building, in conflict-related sexual and gender-based violence. And Professor Beku is going to present her research on crime of persecutions.
Thank you, short person alert here. Okay, thank you very much. It is a pleasure to be speaking at this event on the roots of criminalizing crimes against humanity. I would like to thank the organizers for bringing us together, and this is my very first time in Poland, so I'm very grateful for the Pilecki Institute's hospitality. This conference takes place at a particularly crucial moment as negotiations are underway towards the adoption of a new convention on the prevention and punishment of crimes against humanity. In this context, revisiting the origins of this body of law is not simply historically interesting, but it's also necessary. Among the various acts that constitute crimes against humanity, persecution occupies a particularly important place, as it captures the denial of fundamental rights, human rights, on discriminatory grounds. When Patricia invited me to this conference and she mentioned the roots of persecution, I started imagining crimes against humanity as a tree. Roots, branches, but also new shoots, if not flowers. So in my presentation today, I will try and trace the roots of the criminalization of persecution as a crime against humanity, focusing especially on the crystallization at Nuremberg and the developments that followed. I would also try and reflect on how the legal choices made at the time continue to shape and in some respects restrict the current framework around persecution. Let me begin by saying that I do not consider Nuremberg the starting point for persecution. Even before it was recognized as a crime, it was already a political and social reality. For example, one of the clearest early examples of persecution is the persecution of the Armenians in the 1915 massacres. At the time, these acts were described as crimes against the laws of humanity. Yet, despite this moral condemnation, there was no effective legal response. There were, of course, some attempts at Versailles Peace Conference to establish responsibility, which, as we all know, ultimately failed. It is only in the aftermath of the Second World War that persecution became firmly embedded in the international criminal law. The Charter of the International Military Tribunal, adopted in London in 1945, marked a foundational moment. For the first time, persecution was explicitly included as a crime against humanity, alongside murder, extermination, enslavement, we've just heard, deportation, and other inhumane acts. This was a profound innovation. It allowed the international community to address atrocities committed not against enemy populations, but also against a state's own citizens. This was particularly significant in light of Nazi policies which had targeted Jews and other groups within Germany and beyond, and before the outbreak of war. As Robert Jackson, the US chief prosecutor at Nuremberg, made clear during the drafting process, there was a very strong intention to ensure that such persecution committed since 1933 would fall within the tribunal's jurisdiction. At the same time, however, this innovation came with a crucial limitation. Under Article 6C of the London Charter, persecution on political, racial, or religious grounds could only be prosecuted if it was committed in execution of or in connection with another crime within the jurisdiction of the tribunal, namely war crimes and crimes against peace. While the so-called nexus requirement mitigated concerns over retroactivity and sovereignty, it had significant consequences. In practice, it meant that the extensive persecution of Jews and other groups occurring in the 1930s, although very well documented and clearly established beyond all doubts before the Nuremberg Tribunal, could not form the basis for convictions unless it was linked to the war. While the tribunal acknowledged that persecution before 1939 had been systematic and widespread, it nevertheless concluded that these acts did not fall within its jurisdiction as crimes against humanity because the required connection had not been sufficiently established. As a result, although the Nuremberg Tribunal, as well as the Tokyo Tribunal, recognized persecution as a central component of crimes against humanity, some of its most emblematic instances were effectively excluded from their legal reach. In particular, acts that occurred before the war. Consequently, no convictions were entered for those acts. Despite this constraint, the Nuremberg trials were crucial in shaping our understanding of what persecution entails. The tribunal examined a wide range of acts: discriminatory laws, excluding Jews from public life, restrictions on professions, deprivation of citizenship, economic dispossession, the imposition of collective fines, and measures such as forced segregation, including the creation of ghettos, as well as the requirement to wear identifying symbols. These acts, taken together, illustrated that persecution is not limited to physical violence. It is a process, often gradual, involving the systematic denial of rights and the progressive marginalization of targeted groups. In the years following Nuremberg, there was a clear effort to overcome the limitations of this initial framework. The Control Council Law No. 10, which covered subsequent trials, removed the nexus requirement. This marked an important shift, recognizing persecution as a crime that could stand on its own. This development was later reinforced by the jurisprudence of the International Criminal Tribunals for the former Yugoslavia and Rwanda, as well as nearly all internationalized tribunals such as the Special Court for Sierra Leone, the Extraordinary Chambers in the Courts of Cambodia, and the Kosovo Specialist Chambers, which confirmed that no connection with other crimes was required. These tribunals also played a crucial role in clarifying the elements of persecution. They defined persecution as the gross or blatant denial on discriminatory grounds of a fundamental right laid down in international customary or treaty law, reaching the same level of gravity as the other crimes against humanity, and emphasized that it could take many forms. They also highlighted the cumulative effect of persecution, the cumulative nature of persecution. Acts that may not appear sufficiently serious in isolation can, when considered together and evaluated in context, amount to a crime against humanity. This evolution reflects a broader understanding of persecution as a flexible and dynamic concept, capable of capturing wide range of discriminatory practices on the basis of political, racial, and religious grounds. These may include acts that do not necessarily in themselves rise to the level of inhumane acts, such as certain forms of property destruction or dismissal from employment. Against this backdrop, the work of the International Law Commission on the Draft Code of Crimes Against Peace and Security of Mankind further consolidated the understanding of persecution that had emerged in post-Nuremberg jurisprudence. Building on progressively developed approaches by the ICTY and the ICTR, the Commission refined the concept of persecution towards a broader conception, which was based on denial of fundamental human rights on discriminatory grounds, while consistently retaining the political, racial, or religious grounds, and eventually adding ethnic grounds as the core protected categories culminated in the final 1996 draft code. The subsequent adoption of the Rome Statute of the International Criminal Court represents both progress and, in some respects, regression. Importantly, Article 7 provides the first treaty-based definition of persecution, defining it as the intentional and severe deprivation of fundamental rights, contrary to international law by reason of the identity of the group or collectivity. In doing so, the statute largely formalizes an understanding that had already crystallized through Nuremberg, subsequent jurisprudence, and the evolution of customary international law. At the same time, the statute significantly expands the list of protected grounds. In addition to political, racial, or religious grounds, it includes national, ethnic, cultural, and gender-based persecution, as well as other grounds that are universally recognized as impermissible under international law. This expansion reflects developments in international criminal law and acknowledges the diversity of forms that discrimination can take. However, on the other hand, the Rome Statute reintroduces the nexus requirement. Article 7 provides that persecution must be committed in connection with other acts or crimes within the court's jurisdiction. This reintroduction is difficult to reconcile with the evolution of customary international law, which, as we have seen, moved away from such a requirement in the decades following Nuremberg. The implications of this requirement are not merely technical. They go to the heart of the preventive function of crimes against humanity. If persecution can only be prosecuted when linked to other crimes, then the law risks intervening too late, only after violence has escalated, excluding persecutory acts that may occur before the commencement or preparation of other crimes. Yet, history shows that persecution often precedes and enables more extreme forms of violence. This discussion brings me to the present moment and to the ongoing negotiations on the Convention on the Prevention and Punishment of Crimes Against Humanity. Over the past year, I've had the privilege of chairing the drafting committee of the American branch of the International Law Association's study group on crimes against humanity. And our compilation, which you can find it online, and I've got a copy of Persecution here, offers a number of proposals, 14 in total so far, including one on persecution. I was also fortunate to have joined the first session of the PrepCom in New York with regard to this new convention in January. One of the aims of this proposed new convention is truly to prevent crimes against humanity, as well as punish them, of course. Then, if that is the aim, it is essential, in my view, to assess the limitations that continue to shape the legal framework on persecution. I believe that 2 points in particular deserve further attention. First, there is a strong case for removing the nexus requirement. Doing so would align the definition of persecution with customary international law and the practice of most international tribunals, as well as at least 25 countries across different regions and legal traditions that prescribe persecution in their domestic legislation that do not have a nexus anymore. More importantly, it would allow states to respond to persecution at an earlier stage, before it escalates into more extreme forms of violence. Second, consideration should be given to further expanding the list of protected grounds. While the Rome Statute represents significant progress, contemporary patterns of persecution suggest that additional grounds such as age, disability, and indigenous status should also be explicitly recognized. This would ensure that the law remains responsive to evolving forms of discrimination. To conclude, the history of persecution as a crime against humanity reveals both continuity and change. From its early recognition as a moral wrong, through its codification at Nuremberg, to its subsequent development in international criminal law, persecution has remained central to our understanding of crimes against humanity and mass atrocity more broadly. At the same time, the legacy of Nuremberg, particularly the nexus requirement, has had a lasting impact. And if we go back to my tree analogy, sometimes it is required to prune the tree to allow for new shoots to flourish. As negotiations advance toward the new Convention on Crimes Against Humanity, there is an opportunity to go back to the roots of persecution and learn from the history and its legal implementation. By removing certain now outdated constraints and by adopting a broader, more inclusive approach, the international community can strengthen its ability to both prevent and address persecution in all its forms. By pruning the tree whilst preserving the strong roots, we can, in essence, hope that crimes against humanity will flourish and maybe we will enjoy beautiful flowers in the end. Thank you.
Thank you very much, Professor. And our last speaker is Dr. João Fusco Ribeiro from the Pilecki Institute, who is an assistant professor at the Center for Totalitarian Studies here. And his research focuses on African liberation movements and the transnational networks of anti-colonial solidarity that connected them with Eastern Europe, and the emergence and consolidation of Afro-communist regimes inspired by the Soviet model. And Dr. Ribeiro is going to present a paper which is titled Crimes Against Humanity in Colonial Africa, a Historical Perspective.
Thank you for the kind introduction. And for the invitation. Of course, it is a great pleasure to be here. I should start by saying that I do not have any background in law or in legal history, so pardon in advance any lack of legal clarity that you are more than welcome to correct me during the debate. My academic training is in the field of African history, and what I'll try to do here is essentially provide some past examples on colonial crimes in Africa. And if there's time to engage on a discussion on the concept itself. Even though I'm more focused about the past, I think it's important to briefly address the current relationship between Africa and modern international law. We should have very present in mind that Africa is by far the region of the world with more international criminal court investigations, and many regimes with appalling human rights records see international law as a threat and adopt a populist discourse by demonizing international justice institutions as Western hypocrites or as instruments of neo-colonial interests. And this kind of populist discourse, the impact of this populist discourse on African audiences should not really be overlooked. Secondly, and coexisting with what I just said, the countries of the Global South have legitimate grievances with what they regard as a chronic deficit of accountability of the Eurocentric post-war international legal order, one that, by design, upheld imperial rule while consistently turning a blind eye to colonial crimes throughout the second half of the last century. And it was out of this criticism that the legal school of thought, widely known as third world approaches to international law, appeared, which is relatively unified in the criticisms that it makes, but much more fragmented and sometimes subjective on the concrete alternatives they propose. From an historical point of view, colonialism has had a profound impact on human history. Roughly 80% of the world was at one point or another, under formal colonial rule, and this was a process that existed long before, during, and after the establishment of post-Nuremberg international law. By definition, colonialism required the systematic use of coercion against civilians. It's something that is inherent to the system and part of a wider global history of mass violence. The vast majority of these crimes, of this colonial violence or colonial atrocities, would fall within the legal categories of what international law defines as genocide, war crimes, crimes against humanity, and crimes of aggression. And I will proceed to provide some concrete historical examples immediately. Regarding colonial atrocities, the German genocide in Namibia is, in my opinion, a good entry point because the intentions of the colonial power were clear and unambiguous. There is vast amount of evidence on the intent, the planning and execution of the systematic extermination of the Herero and Nama communities, as well as reliable archival evidence that this was not the action of a rogue German military commander or local administrator, but that this campaign of mass extermination was ultimately decided at the highest levels in Berlin, which is a detail that is very far from irrelevant. There is also broad consensus among historians that these events in fact constituted a genocide. Some even argue that this was the first genocide to reflect the hallmarks of modernity. So this was not privatized violence carried out by settlers, but state-sanctioned systematic extermination decided at a very central level, and it involved a technologically modern army engaging in chemical warfare and the mass imprisonment of entire communities in concentration camps. When dealing with these kinds of historical atrocities in the age we can call the age of classical imperialism, a persistent argument is, of course, that these acts were not considered international crimes at the time they occurred. Nevertheless, there is a strong case that Germany did, in fact, breached its international law obligations. The Berlin Conference, which granted the German Empire sovereignty over Namibia and was ratified by almost every European country, legally binded its signatories to safeguard the well-being of the local communities. For an historian, this has three major limitations. The first, almost ironic paradox, an international conference convened to divide Africa among imperial powers, having a patronizing reference to regarding the welfare of the very people who were soon going to be colonial subjects. Secondly, and unsurprisingly, all colonial powers, not just Germany, violated Article 6 of the Berlin Conference. And finally, while Article 6 was invoked by Great Britain following the First World War in response to the German atrocities in Namibia, it was not used to criminalize Germany's actions or even to compensate the African victims. Instead, Great Britain cited the violation to argue that because of Germany's breach, it was the British Empire and not Germany who should administer Namibia in the future. So in short, the International Convention of the time was not designed to criminalize colonial actions, rather it served to justify the expansionist agenda of rival imperial powers, in this specific case, Great Britain. Another example I would like to highlight is precisely connected to the British Empire, the concentration camps in the Anglo-Boer War in South Africa. There is strong historiographical consensus here that this was not a genocide, but rather a case of forced relocation and mistreatment of civilians, carried out with the clear military objective of separating the rebels, or guerrillas, or partisans from their local, popular, logistical networks. Importantly, and despite their skin color, this also constitutes a colonial crime because the Boers, descendants of the Dutch settlers of the 16th century, were perceived by the British as ultimately inferior, as backwards, Africanized, deeply religious, stubborn, agrarian people who rejected royal authority. These camps sparked outcry across European public opinion. At the time there were massive street demonstrations, calls for urgent humanitarian aid to be delivered to the victims, and widespread anti-British sentiment. This probably represented one of the first major massive public debates over colonial crimes. The discussion was not necessarily framed in explicit colonial terms, rather it focused on the idea of British illegitimate aggression against independent white republics in Africa. So the shock here was that this was a colonial campaign waged against states with European-style institutions and laws, rather than against the so-called uncivilized African tribes who lacked any sort of recognition, international recognition as states. And these images remained in the public consciousness for many decades, and before the Second World War, they were widely the most recognizable reference for concentration camps in European audiences. Now, fast forwarding to the post-war period, the second half of the last century was when traditional transatlantic empires faced the mounting pressures of decolonization, and there was a rapid proliferation of independence conflicts across Africa, but also across Southeast Asia. And it's precisely during this phase that the inability of modern international law in dealing with colonial crimes becomes all too obvious. For example, crimes against peace were defined in a way as to criminalize only interstate wars. So as a result, wars of liberation within sovereign imperial territories were treated as simply internal disturbances or domestic unrest, even though national independence struggles were deadlier conflicts and killed more people than classic interstate wars in the second half of the last century. This logic also naturally extended to war crimes law. There was no criminal liability for violations of the Geneva Conventions in such conflicts. This changed in 1977 under pressure from the global South states, but by then it was too little too late. Decolonization had almost run its course, and in the African context, this arguably impacted only the Western Sahara insurgency against Morocco, which is still ongoing. Regarding crimes against humanity, as we have heard throughout all this conference, a comparable limitation existed. So prosecution of such crimes was restricted to acts committed in connection with crimes against peace or war crimes, which meant again that accountability for colonial crimes was beyond the reach of international law. This requirement of linking crimes against humanity with international armed conflicts was gradually dismantled in the beginning of the 1990s, first in the aftermath of the events in Yugoslavia and Rwanda, and finally culminating with the Rome Statute, which made the definition much more applicable. So today, the debate within the Global South is profoundly influenced by this idea of a real lack of accountability on atrocities that were committed against them in a very recent past, and a lack of accountability caused by the European empires being the architects of international law and designing it in such a way that they would not criminalize themselves. And also the perception that when there were reforms on the international legal framework, they were conveniently late to criminalize imperial actions. And this makes way for the argument that some Global South intellectuals, make not necessarily legal scholars, that colonial crimes should get its own separate category as an international crime. From the point of view of an historian, this is a huge challenge because defining the boundaries of a colonial crime is not necessarily subjective but can be extremely broad. Much of the internal violence between Europeans can also enter into this definition. For example, the German occupation of Eastern Europe during the Second World War can easily fit the concept of colonial violence. In fact, over the past few decades, German historiography, after a prolonged debate with many resistances, has come to increasingly accept the argument that the war in the East was a colonial war of conquest and annihilation that was not unique or historically exceptional, but rather part of a broader global history of mass violence characteristic of European colonial empires. And this perspective should also encourage a more comparative understanding of colonial violence, which is not necessarily confined to any single region or historical context, while still recognizing that the Global South was among its most enduring victims. So by setting colonial crimes as an independent legal category, as some Global South intellectuals argue, there is the real danger of semantically detaching crimes that already have a name and a definition by introducing a subdivision based primarily on historical geographic differences rather than on the actions committed themselves. So when engaging in debate with the Global South, it is important to acknowledge the legitimacy of their past grievances, and at the same time, it is also worth entering in the discussion if the problem lies not in what they perceive as Eurocentric, universal legal definitions themselves, but rather on the persistent historical failure of international law to apply them, particularly regarding, of course, crimes committed under European imperial rule. And perhaps most of the Eastern European countries, due to shared parallels in imperial domination and independent struggles, are best positioned to engage in this debate rather than the former colonial powers. Thank you for your attention.
Thank you very much, Dr. Ribeiro, for your presentation. According to the schedule and to the program, our panel should end right now, but I think we can gain like 12 minutes for the discussion, so the panel ultimately will end at 12:30. So please join the discussion. If you have any questions to our discussants, go ahead.
Thanks. I have kind of a technical question for you, Olympia. As you know, the nexus requirement became an issue at the Cambodia Tribunal, where the defendants argued that between 75 and 79, custom had not yet replaced the nexus. They obviously lost that, but I'm curious to know what you think of it. To me, it was not an unreasonable argument, given that if you look at what the Cambodia Tribunal cited, they cited Law Number 10, Flick, or Justice and Einsatzgruppen. So they cited the ones that were dicta, and they ignored all of the holdings that said actually the nexus is in Law Number 10. So I'd just be curious if you have any thoughts on that.
Yeah, thank you very much for the great presentations. I have a question to Dr. Ribeiro. Basically, I was wondering why you didn't mention the Belgium example, because I mean the Belgium case was also related to the Berlin conference, and also because there has been this massive civil engagement with regard to the crimes of Leopold II. Basically, this was also one of the occasions where the concept crimes against humanity came up, which was brought up by Washington, by the American journalist and historian, and I mean also because Belgium is similarly Germany. Struggling with this legacy right now. So I mean, there has been this late excuse by the Belgian king recently. So maybe you could say a little bit on this case as well.
So I have two questions. One would be for Professor Adenen. There have been some thoughts on including slave trade as a distinct category of crime against humanity, and I was wondering whether you could offer some thoughts and offer some thoughts on the distinguishing between enslavement and slave trade. I always thought that, well, enslavement would be a practical or a functional precondition for slave trade. So could you offer some thoughts on that and whether that's useful? And then one more question was for Professor Olympia, to stick with your analogy. I was wondering whether, indeed, the act of pruning the tree, as you called it, whether it could not be perceived by some powers such as China, India, and Indonesia as, well, eradicating the roots that make the tree acceptable in the international garden, or a garden of international law so far. And I'm asking that in the context of, the first PrepCom and the position of Indonesia and China specifically.
I have a follow-up question to Amina, exactly related with the slave trade. My question would be that based, you presented the history of criminalization of the enslavement, but when you analyze all those cases from the past, whether they included slave trade without distinguishing this as a separate crime. So just to be more specific, whether in those cases where the enslavement was prosecuted, they did also refer to the slave trade without distinguishing it as a separate crime. I also have the question, which I would like to link with the presentation of João, because I fully agree with your conclusions concerning that to show this context of colonial violence as that these were typical genocide or crimes against humanity crimes. But I would like to, referring to your presentation, but ask a question to Olympia. Olympia, because you were firstly because you were involved in Abila works and you were attending the PrepCom, and my main concern is, and that's why I asked João to present on colonial violence, because this colonial violence is appearing in the statement of many African states, which really wants to have reference to this. And they would like to have some kind of separate crime concerning this colonial violence. But honestly speaking, and maybe this would be our Eurocentric approach, we don't get it what they want in this convention specifically, how to address their concerns. So from your perspective, would it be sufficient just to refer to the past and to the history and to notice that the colonial violence was characteristic for the colonial times, and but now it's already covered by different notions like João presented, or we need something else? Thank you.
Shall I start? Okay, Kevin, I totally agree with you. I think it's an issue, but of course, as with every customary law, you have to try and trace the crystallization, and that's the peril of prosecuting crimes so far after they have occurred. So that court took a particular interpretation. A different court may take a different interpretation. I don't think it's an exact science, and I think it comes with the territory of prosecuting crimes so far after they have occurred. I'm not sure this is a satisfactory answer, but that's kind of where I'm situated on that. On the act, I really liked how you use my analogy. It's far more insightful than I had thought about it. But I will respond by saying sometimes it's important to fertilize the tree, and when we're doing progressive development of international law, I will like to think that we should push the boundaries. I understand it's a very difficult time we're at. In fact, those of us who were in New York, we were constantly saying, had we been negotiating the Rome Statute today, we wouldn't have had the Rome Statute we have today, because of certain leaders of certain countries, because of the way the international law, is moving in some respects. And I take what we had seen in New York was the hardening of certain positions. China has always been kind of on the fence, but in New York they were far more vocally against the convention. Indonesia, you mentioned. But it was also Russia, it was also Serbia, it was also a few other states that perhaps took far more conservative positions that personally I would have liked. For example, the gender discussion galvanized many of the African countries, but also the Arab countries. And I think this will be a very live debate between now and the adoption of the treaty. So I guess seeing that it is a negotiation, right? So we will win on certain things, we will lose on others. But my own view is that as legal scholars, we should be advocating for the progressive development of the law at this stage. I'm not a diplomat to try and find the consensus. Where that consensus lies is a different discussion. On the colonial violence, finally, Patricia, it is. I think there is a developing argument, particularly from many African states, that we need a separate crime on colonial crimes. Where I stand at the moment, I think I need to understand a little bit more, like you. On the one hand, we have the expressive nature of a new treaty. So having it in the treaty will signal that we recognize the colonial past. But would this lead to reparations? Would this lead? So I'm not entirely sure where the debate is. My own view is that it might be hard to prosecute it in practice, but I certainly think we need to have that debate now in the run-up to the new convention, whether it makes it in the final cut or not. Simply because I think it's important to acknowledge the colonial past, but bearing in mind this is it's a convention with a view to the future. So I think that will be a limitation, in my view, as to what we can include. Thank you.
Just to connect with what you just said. Colonialism is not necessarily a process that already ended. Colonialism is a setting which is bound to produce international crimes. We can define colonialism as the political domination of a non-sovereign territory by an external force, where normally a foreign elite there's a profound unequal relationship between the foreign elite and the local population. And this unequal relationship is maintained by violence, by systematic violence, everyday violence. Many times through the view that this elite has own racial superiority or even cultural superiority and legitimacy to rule with limited checks and balances in this territory. I mentioned, for example, the Western Sahara insurgency, but there are other many places recognized by the United Nations as non-sovereign territories. And many times this minority also wants to go forward. So a colonial project is not something that exists in the abstract. It has a mission. And when it accomplished this mission, it ends because it was successful or it fails and it was not successful. For example, a good example of colonial projects that reached maturity and ended because they were successful, Australia, for example, Siberia, most of the Americas. Colonial projects that failed mostly in Africa and Asia, or the colonial powers were not able to substitute the local populations, or the resistance of the local populations was too strong. So in this sense, colonialism is nothing more and nothing less than a collection of many international crimes. So I don't know if you want to continue the conversation?
No.
Okay, and we have questions for Amina. Go for it.
Thank you very much for those questions. To respond to the first question as to whether or not the slave trade would come under the definition of enslavement in the modern sense of crime against humanity, I've no doubt that it would. Obviously, for the presentation, I focused on kind of from the 19th century onwards efforts to prohibit the slave trade. If you're thinking of the definition of enslavement in, for example, the Draft Convention on Crimes Against Humanity, which is the exact replica of the sister article in the Rome Statute, it talks about this concept of attaching basically powers of attaching the right of ownership over a person. So if you take that kind of mechanism and apply it to the slave trade, obviously it would apply to that. It's about kind of the control over the person, the case law from the ICTY, I mentioned the Kunarak judgment, and that goes into it in detail both in the trial and the appeal chamber judgment, and they discuss what exactly comes under the definition of enslavement in the context of actions. So they give examples. So for example, restriction on movement, the person's liberty is taken away, they're threatened with force, psychological control over sexuality. So the idea is, I suppose, it's about control over the person, as opposed to, I suppose, chattel ownership, which is more about the person is property, which is reflected in the slave trade. So I definitely think the slave trade historically would come under the modern definition of enslavement for that reason. The thing about slavery and related practices is because you've different types of slavery. You've got obviously the historic slave trade. In the modern context, you've got things like forced labour, trafficking for the purposes of exploitation, and they're all very different, but as long as they meet that requirement of that control element, so a person exercising all powers attaching to the right of ownership over that person, then it will more than likely come under the definition of enslavement. I hope that makes sense. And then to move on to the second question, I think it was by Patricia. So that question was related to the presentation that I gave, where I focused on slave trade and whether or not those efforts related to other acts of slavery. So those, I suppose the presentation I focused on was based on the slave trade and how through bilateral and multilateral efforts, states addressed that. Now, most of those treaties and bilateral treaties that I was talking about, they focus just on the slave trade. However, if you look to the 1956 Supplementary Slavery Convention, which is kind of the sister convention to the 1926 Slavery Convention, it is more broader in scope, and it focuses on the slave trade and slave-related practices. So by that point in time, I guess, states were willing to take more action to counteract slavery in a wider context than just the slave trade or forced labour. And there's particular reasons for that. If you look in the colonial context, forced labour was a method of violence experienced by indigenous peoples in the colonial context, and that served obviously colonial powers' interests. So again, I suppose if we look to what type of slavery practices were historically prohibited, either through international treaties or other methods, in the 19th century the focus is on the slave trade. Then obviously you've got, with the beginning of the 20th century, you've got treaties that relate to forced labour, specifically in war, obviously in the POW context. But then through the Nuremberg precedent and then thereafter, you have a more expansive effort, or states are more willing to widen that definition of slavery to include not only the slave trade and forced labour, but other slavery related practices. I hope that answers your question.
Thank you very much, Amina, and I think we can now conclude our panel. Thank you for your attention and for your attendance. Now we have a short break, and then we come back here for another panel.
Should I do a test, or is that loud enough? It's okay. Okay.
Only speak to microphone and it will be everything. The presentation is on, and the pilot left-right switch to skip slides.
Oh, okay, very good.
O, mój drug dealer. Szanowni Państwo, dear guests, please let's mobilize ourselves because we are a little bit delayed, but everything is under the control, so don't worry. We will get on track because we have very disciplined now the panelists, and I will even discipline them more. We have the panel on the consequences of the crime against humanity, and we have two very important aspects, because usually when we talk about crimes against humanity, especially in historic context, we do focus on the crimes committed by the armed forces, the crimes committed by the highest state authorities. And what we found is missing in all of this is the role of the police in commission, in perpetration of the of the crimes against humanity. That's why Professor Mark Lewis, who is professor of European history at the City University of New York, but he also sometimes travels here to Poland because he also lectures in Natolin, so that's why he has certain links with Poland, and he has certain links with the question of the with the research on in international criminal justice, as he is a co-author of the book Himmler's Jewish Tailor: The Story of Holocaust survivor Jacob Frank, and he's also the author of the book The Birth of the New Justice: The Internationalization of Crime and Punishment. And Mark decided to to present to us important topic: reshaping trials of police accused of crimes against humanity in order to improve future police forces. The floor is yours.
Thank you very much. Before I begin, I'd like to thank Patricia Grzebek for the invitation and also the support of the Pilecki Institute for inviting me here today. I'm going to start reshaping trials of police accused of crimes against humanity in order to improve future police forces. Police forces, including political police, regular uniform police, and plainclothes investigative police, were some of the main perpetrator organizations that committed crimes against humanity in the Nazi era. Yet transitional justice's problem has typically been that there are far too many police officers to prosecute even a fraction of them. After the period of major crimes is over, some are rehired during the political transition to a successor regime in order to create domestic order and security. Some of the old police return, and some of their institutional practices remain. These include prejudicial attitudes, disregard for human rights, and the expediency of lethal force. How can the prosecution of police be improved to prevent crimes against humanity, and what should be changed in the draft convention? Laws that cancel civil liberties due to a purported state of emergency are the foundation of an authoritarian system. They give the police parameters in which to work, believing they are doing so legally. The classic example is the Reichstag fire decree of 1933, which canceled the civil rights guaranteed by the Weimar Constitution. It gave the Prussian political police, even before it had been integrated into a secret state police or Gestapo, the power to undertake massive arrests of communists and social democrats, the Nazis' political opponents. Discriminatory laws also gave police the framework to repress minority social groups. The 1935 Nuremberg laws defined Jews based on the religion of their grandparents, but also the religion of their spouses. The laws stripped German Jews and also individuals who were born to Jewish parents or grandparents but had converted to Christianity. It stripped them of their citizenship and made it a criminal offense to have sexual relations with so-called German Aryans. In the Nazi system, the investigative police, the Kriminalpolizei, expanded the bureau that dealt with prostitution and homosexual relations to race crimes. Although the Nuremberg laws did not mention the Roma, the police applied it to them too. After the government issued a law in July 1933 requiring sterilization for persons with mental illness, hereditary deafness, and the subjective concept of congenital feeble-mindedness, the police wrote reports about people they thought should be sterilized. With all these laws, the police always had flexibility. They could determine who was politically dangerous, who should be investigated for racial defilement, whether the suspect in front of them fit their idea of a gypsy or wanderer, and whether someone posed a threat to the community of the Reich. In 1938, threat was defined legally so that persons who had committed criminal offenses in the past were defined as repeat offenders who should be locked up preventatively. Threat was defined racially so that persons that racial scientists and criminologists said were inferior, Jews, Roma, Slavs, Asiatics, should be excluded from society, and starting in 1940 and 41, murdered according to the policies of the Reich Security Main Office. Threat was defined hygienically, so that persons who were mentally ill or physically disabled should not be allowed to reproduce. Starting in 1939, in a secret government program, they were murdered. After the war, there was no single police trial per se, but the police appeared in various trials in the three-part mechanism created by the Allies: an international military tribunal to deal with crimes committed in multiple geographic locations, separate military tribunals in their occupied German zones to prosecute war criminals arrested there, and trials in other states, especially those formerly occupied by Germany, to prosecute Germans and non-German collaborators accused of crimes committed against their own nationals. An auxiliary concept was to use the U.S. legal concept of conspiracy, a group of individuals who agree upon a criminal objective but play different roles. This would allow the prosecution of members of the SS and Gestapo in case there was not direct documentary proof or living witnesses to their crimes. Members of the organization could be found guilty of crimes if they belonged to the organization and knew it had a criminal purpose. The first Nuremberg trial of 1946-47 did a fair job of eliminating the Nazi changes to the legal system and evolution of police policy, noting the Reichstag fire decree, the establishment of concentration camps in 1933, and the consolidation of state police and the security service into a central office in 1939, the Reich Security Main Office. The judges had a reasonable picture of the role of the Gestapo in using torture and imprisonment in camps to suppress political opposition in occupied Europe. They also understood the role of the security service members who joined Gestapo agents and criminal police in special murder squads, the Einsatzgruppen, that combed through the occupied Soviet Union in 1941 through 43, exterminating Jews, Soviet commissars, and persons accused of being partisans. Judges cited the Night and Fog Decree of 1941, where the army in occupied territory arrested persons of offenses against the military or Reich and then delivered them to the Gestapo, who took them to Germany, never to be heard from again. Judges understood the role of the Gestapo in enforcing the Germans' forced labor system, both inside and outside the Reich. Workers who tried to escape armaments plants or otherwise violated their contracts were sent to concentration camps. The prosecutors and judges also had reliable information about the death camp system from the interrogations and affidavit of Rudolf Höss, Commandant of Auschwitz, Regarding the role of the police, he explained that in the general concentration camp system, prior to the founding of the Reich Security Main Office in 1939, both the Gestapo and the Reich Office of the Criminal Police, quote, were responsible for arrests, commitments to concentration camps, punishments, and executions, unquote. After the security office, Central Security Office, was founded, their responsibility remained the same. Huss then stated, quote, at Auschwitz, mass executions by gassing commenced during the summer of 1941 and continued until 1944, unquote. Particularly revealing was his account of visiting one of the Reich's 3 already operating death camps, Treblinka. In 1941, the Treblinka commander explained to Huss the use of carbon monoxide gas in fixed gas chambers, unlike the mobile gas vans used by the Einsatzgruppen in the occupied Soviet Union. But Huss observed that the process was inefficient. So, with the help of engineers from Berlin, he made improvements at Auschwitz, building larger gas chambers and introducing the pesticide Zyklon B, which killed people faster. Quote, still another improvement we made over Treblinka was that at Treblinka, the victims almost always knew that they were about to be exterminated, and at Auschwitz, we endeavored to fool the victims into thinking that they were going to go through a delousing process, unquote. But we should not over-idealize Nuremberg. There were numerous shortcomings in what the trial said about police responsibility. Although the judges methodically explained why they ruled the Gestapo, SS, and SD were criminal organizations for their roles in crimes against humanity, they did not make the same judgment about the Kriminalpolizei and Ordnungspolizei, though they knew that both had participated in Einsatzgruppen murders. Second, the only actual police official charged at the first Nuremberg trial was Ernst Kaltenbrunner, the higher SS and police leader from Austria, who took over the Reich Security Main Office as chief in 1943. He signed orders for persons to be transferred to the concentration camp system and signed execution orders, but he was not the author of the original policies. Himmler and Heydrich, among others, were, but they were dead. Third, the judges included a section about the persecution of the Jews in their judgment, finishing with the estimate, which they attributed to Adolf Eichmann, that the final solution was a government program that, quote, resulted in the killing of 6 million Jews, of which 4 million were killed in the extermination institutions, unquote. However, the judgment contained no section about the persecution of the Roma at all. They were hardly mentioned at the trial, although the German police had confined them to work camps starting in 1937. In Austria, they lost their citizenship after 1938, were concentrated in the Lochenbach concentration camp in the Burgenland, then deported to the Łódź ghetto in 1941. Virtually all of them died of typhus or were murdered at Helmno. There was more attention to mid-level and chief police commanders in the Einsatzgruppen trial of 1947-48, which was staged before a U.S. military tribunal. This trial was restricted to the actions of these death squad units during the invasion and occupation of the Soviet Union, so it did not cover pre-war police policies. Prior to the war, the police had extensive regulations about the treatment of Jews and Roma, viewing the former as subhumans and the latter as congenital criminals. This formed the police's pre-war prejudices. The trial also did not concentrate on the training that Gestapo officers and criminal police officers received at the SIPO academies in Berlin-Charlottenburg and Brecht an der Elbe, though several Einsatz commanders had attended them and mentioned this in their affidavits. These Führer schools provided ideological training about race theory and worldview enemies. They also evaluated and selected candidates based on how well they could think on their feet and find solutions to a task. This runs counter to the way their actions were presented by defense attorneys at trial, as obedience to superior orders whose authority they could not question. But, seeing them as free moral agents, judges did not agree with that argument. Judges also nullified the defense argument that the commanders had acted in self-defense of the German people, who were purportedly threatened by Bolshevism, with the Jews as the main carriers. The judges simply rejected this on the basis that the Jews, as well as the Roma, were defenseless and posed no threat to German society. The trial is also notable because the entire prosecution case took only 2 days, with the lead U.S. prosecutor viewing it mainly as a massive murder trial, using documents necessary to show that each commander knew about the executions, supervised them, and/or contributed. The use of the SD's reports, documenting all the locations where the squads murdered people, as well as how they characterized them, saboteurs, partisans, Polish agents, Russian agents, shows how much discretion they had in the field to decide whom to kill. The reports showed that these units worked with local populations in Latvia and Ukraine, for instance, to instigate pogroms against the local Jewish population. But when these were too slow or unsuccessful, the commanders deployed their units and took care of the job. The trial revealed that Gestapo chief Heinrich Müller tasked Paul Blobel, the chief of Sonderkommando 4A, with the task of visiting previous Einsatzgruppen sites in Ukraine and the Baltic states to burn corpses to conceal the evidence in 1943 and 44. This destruction of evidence was similar to Bosnian Serb units in Bosnia in 1992 to 95, when they moved the bodies of murdered Bosnian Muslims from one location to another in order to better conceal them. Although judges found many Einsatzgruppen commanders guilty of crimes against humanity, 10 who received life sentences or the death penalty were pardoned or released in the 1950s. We must consider revising the draft convention against crimes against humanity so that commutations under specific criteria are not allowed. After the international trials, each occupying power had its own approach to denazification in its zone. The Gestapo and SS were dissolved by Allied Control Council Law number 24. Issued on 12 January 1946, it prohibited all Nazis and persons hostile to the Allies from holding public office in any of the 4 occupation zones. Next, the IMT's judgment on the 1st of October 1946 declared that the Gestapo, SS, and SD were criminal organizations, intending that in future trials, persons who belonged to them could be prosecuted for membership if they knew the organizations were involved in criminal behavior. Membership in these organizations, as well as in the Nazi Party, became important criteria for purging post-war police in all Allied zones. However, each occupation government in 1945 to 49 handled this relative to its political and economic goals, which were markedly different in 1946 and 47. The U.S. detained a large number of suspected war criminals and used an extensive questionnaire and a 5-level evaluation system in their zone. Yet in the 1950s, persuaded by West Germany's politicians and former officers' letters of good conduct, they issued pardons and commuted sentences of police officials. In the Soviet zone, the military government rapidly pursued denazification and routinely sentenced police officers accused of participating in liquidations in occupied Poland and the Soviet Union to 20 years in prison camps. They also began building their own secret police force, the Stasi, including personnel who had been in the Nazi-era police. But in the mid-1950s, the Soviet Union released police officers from detention camps, including former Austrian ones involved in mass shootings in Poland. After the occupation of the Western zones ended in 1949, West Germany implemented a law in 1951 that said former civil servants, including the police, who had been terminated from service due to incrimination in the Nazi regime, could be reinstated if their actions were not serious. Austrian denazification was effectively over by 1954, when Austrian special war crimes courts concluded their work and the country regained its sovereignty under an international treaty. Recently, I studied 65 Viennese police officers, then part of the Nazi police, who guarded deportation trains to ghettos and concentration camps. None were dismissed after the war for their role, even though some admitted it. Only 11 were dismissed, but this was because they belonged to the Nazi Party. Their actions during the war were not examined. This leads me to my recommendations about how to improve police trials and the draft convention. Number one, the draft convention must be revised to include universal jurisdiction and international jurisdiction. In the late 19th century, Gustave Moynier, an attorney with the International Committee of the Red Cross, proposed that the only way the Geneva Convention of 1864 could be enforced neutrally was to found an international tribunal. After World War I, the Greek international lawyer and foreign minister, Nikolaos Politis, argued that an international tribunal was needed to deal with crimes against humanity committed allegedly by Bulgarian forces in the Balkans. An international tribunal would help dispel cross-border animus among various national groups. In the first draft of the Genocide Convention, written by Raphael Lemkin, Vespasien Pella, and Henri Dondieu de Vabre, the latter two supported international jurisdiction based on ideas they proposed in the 1920s. De Vabre thought the International Court of Justice could have a special criminal chamber. In the current draft convention for crimes against humanity, Article 13 allows a state signatory to prosecute crimes that occurred on the territory of another signatory, presumably if that state refuses to prosecute them, but it does nothing if crimes against humanity are committed on the territory of a non-state signatory. Powerful states on the UN Security Council, such as China, Russia, and the United States, fear international or universal jurisdiction because they worry that their police, intelligence services, border control agents, and military forces will be prosecuted for these crimes. We know from history that states do not want to prosecute their own. They either bury the evidence, spin the story, move on with a new political administration, or slow walk their own investigations. If more enlightened states join together with civil society organizations, as the like-minded states did during the Rome Treaty negotiations for the ICC, they can achieve a broader jurisdiction. Number two, recordings of international trials involving police must be made more widely available so that police forces can use them in their training. These are now hard to locate and search for in the residual mechanisms of the ICTY and the ICTR. If police officers are shown what can happen to policemen found guilty of crimes against humanity, it can have a deterrent effect. The draft convention should also be revised to state that the new laws should be implemented in police training manuals. Police should be taught the definition of criminal orders and what they should do in case their superior officer gives them these commands. Number three, state prosecutors should be more courageous in opening investigations into police officials who run police training academies, especially the intelligence service programs that teach enhanced interrogation methods. Even if no convention on crimes against humanity is eventually passed, we need more thorough investigation into violations of the Convention on Torture, including the use of sleep deprivation and physical stress positions, which falls under Article 1 of that convention. Number four, the destruction of evidence to conceal crimes against humanity should be explicitly stated in Article 2. one should not assume that this would be covered under Article 2C, otherwise assisting. And finally, number 5. The Convention needs to state explicitly that non-state actors, including paramilitaries and militias, are covered by this Convention. The interpretation that they would not be excluded on the grounds that individuals in them are acting, quote, pursuant to organizational policy, found in Article 2(2)A, is weak. The definition of organizational policy is unclear. Paramilitary and so-called self-defense groups carry out mass rape, forced deportation, and systematic murders to inflict punishment or to ethnically cleanse. We learned this from the wars in the former Yugoslavia, the African World War in the Democratic Republic of Congo, and the current war in Sudan. Thank you.
Thank you very much, Mark. Usually I ask all those researchers who deal with the subsequent Nuremberg trials, like Kevin, like Annette, which trial was missing, yeah? What kind of group was missing? Now we know that definitely maybe we needed the trial which would focus on the responsibility of the police forces. But now we are moving to another direction, another dimension of the discussion of the on the draft convention on the crimes against humanity, and this would be presented by Professor Aleksandra Merzykowska. Professor Aleksandra Merzykowska is a professor of Polish Academy of Science, and at the same time she is she works at the Ministry of Foreign Affairs, and I would reveal that this is the main person behind the coordination of the works in Poland on this draft convention. She coordinates the works between MFA and Ministry of Justice. Representatives of both ministries are sitting in different parts of this room, but they do talk together thanks to Aleksandra. And Aleksandra is also the member of the board of the Register of Damages, so she deals with the implementation of international law in practice, and she also publishes, for example, on the jurisprudence of the European Court of Human Rights. And Aleksandra decided to choose a very hot topic in Poland. So of course I do refer to the question of reparations for victims of crime against humanity. Ola, the floor is yours.
Okay, it works like that. Okay, thank you, Patrycja. Thank you very much. Thank you for inviting me, and thank you for inspiring this event, because I think it's not important not only from the point of view that it is very informative one, so we can learn a lot, but it may be also be useful for other future discussions on the convention. So before I start my topic, so in details, let me say a few very general remarks to bridge what was said now, because until now we spoke about the prosecution of persons responsible for international crimes, for crimes against humanity. And however, the issue of impunity and the issue of reparation are strictly interrelated. So reparations should not be seen as a byproduct of international wrongful act, but as an element or purpose of international justice. And these are not my own words. These are the words of the representatives of Palestine, when she spoke during the PrepCom in January 2026, exactly about the convention on crimes against humanity. So we must treat the issue of reparation not on the equal footing as the issue of prosecution of perpetrators. Turning to the convention and to the draft convention, so the current draft addresses the reparation in quite general terms. So there is Article 12, and this article is devoted to the rights of victims, witnesses. I'm very sorry, I don't have the presentation what I really regret. So Article 12 is the article that is devoted to the rights of victims, right of witnesses and other persons taking part in the in different kind of processes, and it codifies, I can say, codifies the right to reparation in the following terms. So each state shall have the necessary measures, shall take the necessary measures to ensure in its legal system that victims of crimes against humanity have the right to reparation for material and moral damages on individual and collective basis, consisting as appropriate of one or more of the following forms: restitution, compensation, satisfaction, rehabilitation, cessation, and guarantee of non-repetition. So like the whole draft articles, like the draft articles as a whole, Article 12 is the result of a careful consideration and discussion by the International Law Commission. However, the time has come to reflect whether these general terms, whether they reflect the significant legal advancement that that we have seen since the Second World War, that we have seen in the last at least 2 or 3 decades. And what were these kind of developments? So the concept of victims' right to reparation is not a new one. However, it's undergone a significant development after the Second World War. And the formal discourse on victims' rights began within the UN system in the late 60s. And it was not a coincidental development. It ran parallel to intense debates regarding the non-applicability of statutes of limitation for war crimes and crimes against humanity. And a foundational document to which I would like to refer in my presentation is a note by the Secretary General of 1969, which compiled answers of 16 states that submitted their positions on 2 issues. The first issue was exactly the prosecution of crimes against humanity and war crimes, and the second issue was criteria for determining compensation to the victims of such crimes. And among these 16 states, there were different states from different regions with different political and legal systems. Among them, of course, the communist states like Poland, Czechoslovakia, and Hungary, but also the states from the Western Europe, from Western Europe, like, for example, Norway, Switzerland, or France, but also states from what we now call the Global South, like Mexico, Dominican Republic, or Togo. And the primary tension that was identified in 1969 in this exercise was whether reparations should be governed by a universal treaty according to universal standards, or it should be governed within the domestic legal systems. And the proponents of international standards, such states like Poland and Czechoslovakia, Dominican Republic, or Togo, they argued that the gravity of these crimes requires a universal international treaty. And they contend that the victims should not be left to the whims of the perpetrator states' domestic legal systems. They also pointed to many legal and political hurdles that victims encountered when they tried to use the domestic systems of the perpetrator states, like, for example, sovereign immunities, jurisdictional uncertainties, and statutes, of course, of limitation. These hurdles, they simply block the access of victims to justice. Furthermore, these states also warned of the risk of discrimination because when victims are required to apply to claim for reparation before a domestic legal courts of a perpetrator state, of a state that persecuted these persons on different grounds, like nationality, racial grounds, or any others, it is very difficult for victims to achieve anything. So according to these states, giving effect to the right of reparation may be achieved in practice only through ad hoc compensation mechanisms. Conversely, there were states that preferred domestic tort law and bilateral agreements. These were mainly the Western states. And this division was rooted in historical experience, because countries whose citizens have never received compensation for war crimes or crimes against humanity, like exactly Poland or Czechoslovakia, they sought international oversight. And on the other side, states that were never confronted with the need to pay compensation to victims, or which concluded bilateral agreements after the Second World War with Germany, they strongly opted for domestic distribution. So in the 1969 submissions, the states not only concentrated on, of course, on the way in which victims should be compensated, no matter whether it should be a domestic system or international one. They also pointed to several necessary requirements that this kind of system should follow. And what were these requirements? Let me enumerate at least 4. So responsible states should be obliged to pay compensation that is adequate, effective, and prompt. Compensation should be awarded in a non-discriminatory manner, so regardless of nationality and political relation. It was very important, especially in the context of communist states, and compensation should be transferable to hers, so that ensuring that families of deceased persons are not deprived of the and not denied of justice, and claims should never be subject to the statutes of limitations. So these discussions that started in the 60s, they of course culminated, as we perfectly know, in the adoption in 2005 by the General Assembly of the General Principles and Guidelines on the right to reparation, on remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law. But simultaneously to these developments and to these disputes and discussions at the UN system, significant practice in the field of right to reparation developed. It can be traced in at least 3 areas. So, of course, firstly, a number of human rights treaties that were concluded after the Second World War. There include the provision of on reparation. Of course, the second area of developments in the field of reparation is international criminal justice. And thirdly, victim-oriented right to reparation has been significantly strengthened with the establishment of ad hoc mechanisms. So as we sit now here in April 2026, we must consider whether whether the concerns that were voiced by states starting from the 60s and then during the creation of different kinds of legal mechanisms, whether they have been appropriately addressed in practice. And the answer to this question is yes and no. We have significant practice of states, so states created numerous legal avenues for victims to achieve and claim for these rights. But significant gaps remains. And the main gap, I think these are the domestic jurisdictions, because the domestic jurisdictions are the last resorts for many victims. When they cannot achieve justice on the international level, they will always turn to domestic jurisdiction. And this is the right moment. We know that until the end of April this year, states have the right to submit their proposals to the draft articles, and this is something that will be discussed during the next panel in details, how the states should do it and how to respond to this challenge. But I think when it concerns the right to reparation, we can concentrate on 4 pillars. So firstly, the provision that will be included in the future convention should ensure that access to reparation is ensured through different legal schemes, not only judicial ones, not only judicial proceedings, but also other programs. The systems, all the systems that will be implemented in the future have to be effective. So in the sense that the reparation to victims is not merely symbolic, but it's prompt, full and effective. It is also advisable to consider whether it would be necessary to implement any provisions that will ensure that victims are treated in the future in non-discriminatory manner, especially whether the rights of particularly vulnerable victims are reflected in the provision. And I think to consider these issues is the task of the international community, is the task for the lawyers, for the academics, and for the legal advisors at the ministry. Thank you so much.
Thank you very much. And before we move to the discussion of the legal advisors, I still wanted to give you the chance to ask a few questions if you want to do it. Although I would be completely happy if you are a little bit tired and you want to avoid asking questions now and save them for the lunch. So if there are no questions in the room, then I would like to thank both to Mark and to Alexandra for fascinating presentations on very important aspects which needs to be taken into account in the current negotiations on the convention. And at this moment, I would like to say that as you could see, we started with the perfect keynote speech, and we decided to have this same quality fireworks at the very end, and we are very happy to that two legal advisors of Poland and of Switzerland, Mr. Franz Perez from Switzerland and Mr. Paweł Wierdak from Poland, accepted our invitation, and they decided to show that all those discussions of lawyers and historians, they can matter and they could have some impact and could be then implemented by diplomats. I invite both colleagues to the scene.
Yes, to switch up to unmute. Perfect. Thank you, Professor Grzebek, for introducing us. Ladies and gentlemen, we thought that we can close this the conference with a conversation between legal advisors on the way ahead and on the works that are happening right now on the convention on the prohibition and the Convention on Crimes Against Humanity. I have a huge pleasure of having with me Franz Perez, who is the legal advisor in Swiss Ministry of Foreign Affairs. Thank you, Franz, for agreeing to come to Warsaw and to discuss the convention with me. It's not a secret. We met yesterday. And we had a bigger consultations on international law, but we also talk a lot about convention, and I think this will be a good continuation of what we have discussed yesterday. I have a few questions prepared, but maybe before I start asking a couple of words of introduction. As it has already been mentioned, we are at the very key moment in the process of working on the convention. In less than 2 weeks, there will be a deadline for the states to submit their proposals to the draft articles that has been prepared by the International Law Commission. And countries can present their positions, their proposals that would be then compiled together with the draft prepared by ILC, and they will be basis for the negotiations that would take place in 2028. Poland is in favor of this draft that has already been prepared by the Commission. It is a very solid draft and it's a very balanced one. And for the future process, we would definitely try to preserve its overall architecture, including also its definition that are based on Rome Statute. We are also not in favor of opening any big parts of the draft. However, we have a couple of proposals that we will submit next year. And it may not be a surprise for you, Poland has historically been very much involved in advocating for the rights of the children. And we would also like to use this opportunity, this process, to also present a more child-sensitive approach into the convention. So far, the draft of the convention does not make any reference to any targeted or vulnerable groups. So we would like to use this opportunity that UN member states have to present comments exactly to propose a couple of comments regarding the need to integrate a child-sensitive approach into prevention mechanism, prosecution, but also reparation. Now, coming back to the process ahead of us, as I said, Poland supports the draft, and we think it's a strong and good starting point for the negotiations. How do you think, Franz? How are the other countries looking at it? We also spoke yesterday about the need to build momentum towards the negotiations, and also because this is a UN-based process, we need coalitions. We need groupings of like-minded countries. How do you see this process playing out in coming months?
Thanks, Pavel, and let me first thank you and also Patricia for organizing that event and inviting me. I think it's really timely to begin or to support the process with the first event that looks at the roots of the crime, develops certain necessity to a good understanding of certain important aspects like defining groups or whatever, definitions and shortcomings and successes of the past. I think that's really a great effort and a great contribution to the process. And it's doing a little bit what Sabina yesterday was indicating when she said, well, what was important for the Nuremberg processes was to create that London space. So probably we are now creating here a Warsaw space that brings us together, and what you were just referring to try to build up a space and a coalition where we can bring all our expertise and our strengths together to influence as not being superpowers, but together we are also strong probably and influence the process. And I would like just recall also the 4 elements you were referring to yesterday. Well, a transnational network, I think that is important, and let's hope that we can build on that and build towards that, as you said it, that we bring in legal expertise. That's why it is important to interact also with academia and all that, to institutional embedding. I would say that we just work in that negotiation process and bring in what we find out together. And then, of course, most important is sustainable political pressure. I think that is what will be needed, and we need each other to be able to do that, because each of us alone might not be strong enough. Well, you were just asking about the process as such, and it's interesting from the PRIPCOM and discussions before. I think roughly, to simplify it, you could say there are three groups of countries. There's one group of country, and I have the impression that's the biggest one, where both of us belong to. That's a big group of countries who really would like to have a strong and effective convention on the crimes against humanity, with the objective that it would help us to prevent and also to create accountability for the crimes of humanity. That's the big group, and that's the group that we need. Within this group, there are different nuances. Some, like we think, it's an excellent starting point, the International Law Commission draft, which we will come back to that later with some amendments that will still be needed, but that's an excellent starting point. And others see more shortcomings and try to do more, but that's one group. A second group of countries, I would say, are those countries who engage, but in reality don't want such an agreement. And that's a tactic of some. Also, in other processes, you engage in negotiations. You don't want, you will never ratify. It's clear you will never ratify. But nevertheless, you engage in order to water down and to weaken the agreement, in order to make sure that nothing emerges that indirectly then can nevertheless bind you or hold you responsible. So this is one group. And there is another group, a third group of countries, which is probably the most difficult one, the one who seem to be interested, but at the same time insist that there is a need to ensure flexibility, national implementation, that national sovereignty are important contexts. And in that group, it's difficult to find out, are they really committed? Do they really want something? But they have legitimate interests that they would like to defend? Or are they just pretending to be more interested, but in reality, national flexibility and sovereignty is so important that they prefer to have nothing? So we have these three groups, and that's the reason why I think it is so important what you were saying and referring to. We need a small group of countries like-minded who want a strong, robust convention to be adopted at the end, to strategize together, to think together, and then also to make sure that this first group, the biggest group, will stand together and be able to adopt a good instrument at the end.
Thank you. I totally agree with you. We still have some time till the negotiations will start, and we also yesterday brainstormed how we can exactly provide spaces and platforms for countries, like-minded countries, but also other countries that maybe are not so convinced right now to have them on board. We also mentioned that it is important to engage also in our circle of legal advisors, that we would work on the positions, and then this would be then presented to political decision makers on the future. Right now, we definitely will have to wait for the compiled document that will present the submissions. This will tell us a lot, because from the very submissions we will be able to see how countries are looking at the process, and of course this will come later in the year. However, I would already like to ask you now, what do you think will be the issues that will be the most important during these negotiations? We have the draft prepared from the International Law Commission, so we already know what are the puzzles that will be in the final document. But what do you think will be the most important one, that will, or most discussed one, both in the submissions but then also in the negotiations?
Thanks, Pavel. And let me just build on our discussion yesterday, and also to refer to some of the points you were making yesterday in our discussion. I think, well, for us, it's always important first to understand what is objective. And the objective from our perspective, our common objective, I think, is to have a robust agreement that really helps us to prevent crimes against humanity, and also to hold individuals accountable if they commit such crimes. But this is not the statute of a tribunal. This is of our tribunals, not international. This is creating obligations for states, so that states act together, adopt national legislation with regard to these objectives. So that is quite important. It's really a convention for us as states to work together and to work to that objective. What will be there the big questions to be discussed. One was, it was also mentioned today, and I think also yesterday, that is a question of the definition. There were many comments done on that from states, but also from civil society, from academia. So there are many proposals floating around whether we would have to change the definition. I think we will not propose any amendment to the definition at the moment, because we have the impression the definition as it is now, building on the Rome Statute, but including some small but important changes, like, for example, omitting the definition of gender. We think this is a good and a robust definition. It is reflecting not only that what the Rome Statute members have agreed upon. The International Law Commission included also members from non-Rome state parties, US, China, and so on. They seemed also to support that approach. So it seems to be a definition that has a lot of support. Our approach to the definition is we are ready to look at proposals to change it if it strengthens the statute. So that means if there are acts that today are not captured by that definition, then there would be a good reason to change it. But some of the proposals, our first impression is if you would change the definition, the consequence might just be the different one by becoming more specific on certain aspects. For example, I was raising that question by being more specific, what means a group? You start at once to exclude other groups. So that by being more specific, you always risk to exclude certain acts from it. So I think each of the proposals, we really have to look at them always with a approach. Does that amendment strengthen the coverage of the definition, or does it weaken it? And that needs really, because sometimes you attach to a certain definition for emotional reasons, for symbolic reasons, for whatever. At the end, what we need is that these acts, independent how the wording is, will be covered by the definition. That is the most important thing, and not whether certain symbolic catchwords are appearing in the definition. So that will be one of the difficulties. Then another, we will not make, because we think the definition is fine, but we might learn in the upcoming process now that amendments are needed. A second element, and for us, to be honest, that is the most important one. That is the compulsory jurisdiction of the International Court for Justice. The current draft foresees an option to opt out from that compulsory jurisdiction. And we think that would be a major setback. If you look at a genocide convention, and crimes against humanity are not less problematic than the act of genocide. And we should pursue the same approach like there. And the starting point of the genocide convention is that you have compulsory jurisdiction of the ICJ. And we think that is needed, because we need an instance that where we can go to in order to when we have the impression that one of the other parties is not complying with the obligations, is not doing enough to preempt or to punish acts of crimes against humanity. So, and if we are not able to have a common institution like that, if we don't have a compulsory jurisdiction there, then I think we have a massive problem. So we will hand in a proposal on that. We were discussing there different ways to do it, following the approach of the Genocide Convention, following the approach of the International Law Commission. There are different ways to do it, but that will be our main point. The second point, which is important for us, which is linked to that is, I think we should not allow for reservations. Because that is one of the weaknesses of the Genocide Convention, that it allows for reservation, or it does not exclude reservation, let's say it like that. As a concept, it was that some of the states adopt reservation with regard to the jurisdiction of the ICJ, and we should not allow for that. Then thirdly, a third point where we also make proposal that concerns immunity. Because we believe immunity should not apply in the case of atrocity crimes like crimes against humanity. Well, there are now different approaches to that. Some argue, well, the International Law Commission is now just working on draft articles on immunity, and there the result is clear that there is no functional immunity vis-à-vis crimes against humanity, and that was not disputed. So you could lay back and say, well, that's solved already over there. However, we would like to have clarity on that. And then, of course, the big question will be, do we want also to avoid functional immunity or also personal immunity? These are two. That will be a very difficult question, that will be a terribly difficult question. At this moment, I do not believe that the international community is ready to overcome personal immunity. We, at this moment, we think that would be a nice outcome. And then there are other issues like final clauses, where we will also make proposals which are not politically as important, but at the end, come out.
Thank you very much. These are all very valid comments, and I think also coming back to the definitions, I said that Poland, of course, is very much in favor of Rome statute-based definition, but I also totally share your view that we create an instrument that should be universal. So we cannot close doors to countries that, for example, are not the state parties of the Rome Statute. So it's not only about the substance; it's also kind of a tactics for the negotiations. We also discussed yesterday a lot about jurisdiction, and think here I can also tell you that Poland is also thinking how to approach the issue of let's say monitoring mechanism of the convention, and we are also open for the discussion on the ICJ jurisdiction, but we are also looking at other mechanism, and although we are not in favor of creating a new treaty body, but we will be looking at other options and at already existing mechanism that somehow may be used by the convention. If I may now switch to the Polish proposals, as I said, we will be presenting comments that will center on children, and as it is right now, there is no specific parts that are devoted only to vulnerable groups. So we will be proposing parts on children, but there are other groups that could be included, like people with disabilities, people in certain situations, women. How do you think is this something that would be supported by other countries? How other countries are looking at this sectoral approach?
Thanks. And that was helpful from our discussions yesterday, because our understanding at this moment is that yes, of course, we want to be sensitive to vulnerable groups, or especially targeted group, whatever the formulation is. We do not think that we need at this moment to change the definition. But as I understood your proposal, I thought that was really interesting. It's not only, this convention is not only about the definition, it's also how to interact with special groups. And you convinced me by indicating the interaction with children in such proceedings has to be different one than with old white men that are wearing glasses. I think that is clear, that because there is a special sensitivity. And so we will be looking really positive at that to see that is something that could really be a help to all of us to identify common best practices, how to interact with specifically sensitive groups. It will always be a challenge to remain at a sufficiently abstract level that you do not at once without intention be so specific that it would harm other groups, but at the same time I think children is a good example, where we all have also experience at the national level. You cannot investigate with children specific cases in the same manner like you can do that with the adult. So I think that could be certainly something that can be helpful for all of us, and I think that is also something that should I expect not be a problem. Certain issues are emotionally so difficult that it might be better not to go into details, because that would only create problems. I think this is something where we should be able to agree. So we will be looking, the time is running until the submission, but that is an area where we really look positive at it. And that's the reason why we have to continue to discuss and learn from each other.
Thank you very much. And as you say, this is exactly the huge added value of meeting and discussing, talking, but also inspiring each other, because there are also parts that we have been inspired by our discussion, and so thank you very much. Before I open the floor to questions, maybe just one point from me. There is a long way ahead of us before negotiations. There will be another preparatory committee meeting next year, and then the negotiations will start probably in 2028. So we don't know what the world will be in a year and a half. But if you now looking at the process so far, do you see what are the biggest challenges, or what can be the unforeseen challenges? Because so far the process it takes a little bit of time, but it's moving forward. As you said, there is a majority of member states that really are interested in this document. But what we can expect? It can be challenges not only within UN, but in general in the world, that can actually make it more difficult for countries to agree on. And is there any way we can prepare ourselves for it?
Well, what is the biggest? I think the biggest challenge will be to keep that first group together and to make sure that we are not going to compromise with parties who anyhow will not ratify. That is, of course, I think we shouldn't. That's something you don't say in the plenary. You always say we strive for consensus and so on. Of course, we strive for consensus, but it doesn't make sense to strive for consensus with someone who just doesn't share the same objective. And that's the reason why I think we really have to be clear. We who want a robust have to be clear what is the minimal requirement in there, and there we should have a coalition that is strong enough to say, and there we do not compromise, even if I go to a vote. And if we are strong on that, and if we are clear that we would be ready to go to the vote, then we might not have to go to a vote. But if we give the impression to the others that we do everything to have consensus, then some of the really important backbones of that convention will be dropped. So I think that is one of the challenges. Another challenge will also be that if we are creating an atmosphere that if you cannot take a stubborn approach and look at the proposals, but if it becomes too emotional and if political correctness becomes more important than substance at one moment, then there's a risk that we start to have lengthy debates on issues that will not really make a change and enhance our objective. But so I think we should also have spaces where we can really be very honest and look at proposals and say, well, will that really make a difference? Will there any additional act be punishable and punished and prevented if we do that change? Or is that the proposal that will just be seen by some as so absurd from their perspective that they will walk away, or that we lose a lot of energy by bringing us together? I think there we really need to be able to on one side, it's always nice to say that the best can be the enemy of the good. Here, I think the best is not to be seemingly ambitious, which doesn't change anything into reality. So that will be the second, I think, the one just to make sure that we do not compromise with those who anyhow will not join. And the second will be not to get lost into battles that at the end do not advance the whole project.
I totally agree with you, and I think that we cannot allow ourselves to be dragged into the discussions, endless discussions, and in a way be provoked by those who, as you said, they really don't want to be involved in a good faith in the process. But also you raised a very good point about the consensus versus vote thing. Having served 5 years in New York, I know that vote is the worst thing that may happen. Maybe it's not, actually, and as you say, maybe it's better to have a very strong text than to have a text which is watered down and which requires from us compromising on a lot of our initial thoughts.
Okay, just on that.
Yeah, absolutely. Yeah,
I think first of all, we are used in Switzerland to vote every 3 months, so voting is nothing threatening for us at all. But I think in the UN context, what is important to understand is by being clear that we can vote, that allows us to strive seriously for consensus, because striving for consensus means that you try to find a solution that fits the objectives of everybody, but not that you just go to the low, that you just accept whatever the weakest position is, because so the only way to seriously be able to strive to consensus is by being clear. If you do not honestly try to find a solution, then we are going to vote, and then the other partner will try to engage to find a consensus solution.
Ladies and gentlemen, now floor is yours.
Thank you very much for being here today and sharing your insights with us. I have a question that's obviously coming from a scientific background. So I totally understand from a political level to make strong the idea not to change the definitions of the Rome Statute and saying, okay, we had a consensus on this definition and this is very strong. On the other hand, doesn't it mean to lose the opportunity to further develop international criminal law? So the definitions of the Rome Statute are almost 30 years of age, and probably we have learned a few things in the last 30 years, and this would be an opportunity to include crimes against children, to get rid of the nexus requirement and persecutions, to extend the idea of apartheid and say we must go beyond the South African example, which is historically strong but perhaps too much modeled on a certain case. So it does not mean to miss a chance to say we won't go beyond, or we don't want to question too much the established definition of the Rome Statute.
Thank you very much. It's wonderful to hear you talk about your exchanges and your respective positions. I was wondering if you can expand a little bit on the treaty monitoring body that you envisage. I think it's a very important part of what's missing, in my view, from the current draft, and it's needed. In the Abila study, we have a suggestion, so I'm curious to see what is your recommendation that is not involved building a new treaty monitoring body. Thank
you. So maybe I start with the question, the second one. Well, we don't have any specific proposal now. However, we will be looking at already existing treaty bodies, but also already existing special procedures. We don't really think it's necessary to look at to create a new treaty body, especially now given the whole atmosphere in UN, also financial one, and this would be another burden. However, we feel that with the definitely with the reform of the treaty bodies and the mechanism, there is a space for the convention to use these bodies already existing and all this expertise. So we will be looking at it. We will have discussions also in Geneva to have a better also understanding what is possible and what's not. It's still a little bit of time. Of course, this will not be included in the submission, but in a way we are doing our homework ahead of negotiations. We'll see what other countries will propose in this matter. We just want to be prepared with our own outlook.
Thanks, and I think that's right. There is a situation of that we need a treaty body reform of the existing treaty. First of all, these treaties, where we have treaty bodies, are all treaties about individual rights of individuals. So that is a different situation here, because we are looking about states' obligations to cooperate and so on. But we will need. We thought the ICJ jurisdiction might be the best way forward, but perhaps there might be another. So that is why we need this interaction and thinking together to find solutions. On the other question. First of all, I'm always absolutely in favor of progressive development of international. I think that's what we need. But I'm not sure that these proposals would pretend or seem or aspire to be a progressive development where they really are doing that. I think in the crime against humanity, I think what is important is that these acts are covered by the definition. And if there is an act that is not covered by it, then we have to look at it. I think that is so. The nexus was mentioned. This nexus, when it comes to the issue of persecution, this is something we have to look at. Our possibility, we will have to be. I personally have to better understand why do we still have that nexus in there. I do not fully understand that. There might be a reason behind it, and if there are possibilities, because that seems to limit it. But on many other of the proposals, I'm not sure that there, because it's not more progressive just because we have new catchy words in there, if it doesn't change anything about what can be prosecuted or not. I thought it was really interesting, the discussion which you had earlier, where we were also part of where it was of a specificity of children, of women, of gender, and so on. When it came to the question, do we need to define gender? And then I think it was you who said, no, we don't need to define that, because that is only bringing us into problems, because if we define it like that, if we define it the way like we see it, as it should be defined, that will be not acceptable, we know that. There's no need to do that. Then I ask myself, when it comes to the definition of identifiable group, is there a benefit of starting to list and identify groups? Does that add something to it or not? I'm not sure that it will, because we have now, it's an identifiable group, cannot be prosecuted, that is a crime. That covers children, women, men with glasses, whatever you want, as long as there's a certain thing around it. And is that not so? So if you have a good reason why this is not sufficient, and that should be more than the symbolics at the end, because the more precise you are there on the definition of a group, the more there's a risk that you exclude future other groups. So that is a delicate balance. When it comes to gender apartheid, we had an interesting seminar on that back-to-back with the CADI. That's a meeting of the legal advisors of the members of the Council of Europe, where that issue came also up, and we interacted with a prosecutor from Germany. And he said, well, first of all, gender apartheid, to define it is a nightmare. Secondly, also, she didn't believe that any additional act or situation would be covered by bringing that in. It would just create something that is not vague, and there is a risk that then certain gender policies that are not reaching the level of a not yet defined standard of gender apartheid, then at once would be excluded. So this is this aspect. But there's also another one. I think apartheid is a very specific issue. And we should not start to try to weaken the strength of that term by using it also for other things. I do not want to say that what is happening in Afghanistan, what also is happening in our countries with regard to women or other groups is not terrible. I don't want to say that, but just one tool that was developed specifically for one area. By starting to use it for a totally different area, there's a risk that it isn't as forceful anymore for the first area, because then it becomes blurred and it becomes imprecise. But if there is a way to strengthen the protection, for example, of women, by changing the definition without the risk of excluding certain activities, then that's fine. But for the moment, I'm not that convinced that such changes will really reflect a progression in international law. I think there's rather the risk that it would lead into preventing progression in the future, because progression means also to formulate obligations in a manner that they're future-proof and that they are not preventing future evolutions. But this is things where I think we really have to sit together and think that through. And think through what is helping it to strengthen the convention without sinking it, because then some will walk away. But whenever we are able to progress and keep the momentum and strengthen momentum, then we will be all in for that.
I think we agree here. There are a couple of issues. One is exactly that the more detailed we are, the more we limit maybe the applications for the future. Good definition should be the one that also includes something that we don't know now. My second point is there were a lot of processes that failed on the stage of definitions. And then, of course, there is a tactical point that you also mentioned. Opening these definitions may require a lot of time. And then, of course, it's our decision how much time we would like to spend on negotiating this document. Maybe there are other parts that are more important. So that's. But as you say, we are just reflecting on this. Any more questions?
And on the division, I think so, because my concern with regard to division, one of my concern is that there are so many countries who, from whatever reason, for them, paragraph 3 of the definition of a Rome Statute is important. And if you start to change the definition, it will be very, very, very difficult to prevent the definition of the gender. So this is something where it's always at the end. And that would be step backwards. That would be a tremendous step backwards if you would have to. Yes.
Please.
So I will leave definition, but I would like to ask you about your proposition that we need to have compulsory jurisdiction of the ICJ and to not allow to submit reservations to the convention. But my main concern is that if I refer to the advisory opinion of the ICJ on the reservations to the Genocide Convention, it was stressed in this advisory opinion that in case of the human rights treaties, which Convention on the Crimes Against Humanity definitely would be, in this case, it is even recommended to allow reservations because this would secure greater amount of ratifications. So my main concern is that if we are pushing for the lack of reservations and for the compulsory jurisdiction, maybe we would end with the convention, which will be ratified by very few states, and we will not have any instrument which would impose obligations of many states to implement them nationally. So this would be my question to you as a lawyer, and another question which I have to you as a diplomat. I could observe you that, yes, I love your principled approach, and I could observe you as a really legal fighter during the discussion on the amendments on the crime of aggression. And I do remember those discussions that we need to be prepared for the vote, but what to do to not only to build a momentum, but also to take into account that usually the biggest number of states which we observe in the room, this is the silent majority, or absent majority. How to avoid the situation that we will have the negotiation and we would not have enough states to have a vote because they would be absent or don't take officially a part in the vote. Thank you.
Maybe one more question.
Thank you so much. So two of you, it's very exciting to listen to you discussing these upcoming preparations for a convention. It's a very exciting moment in history, I have to say. I was actually not sure whether that would come about at all, and we have now this window of opportunity, a Warsaw moment, a New York moment, whatever that will be. But it's I would have probably lost a lot of money had I bet on whether the UN would actually go ahead and open this this window. So there it is. And the question is now also to what Patricia said. What would be the outcome? Because, I mean, we have a definition in the Rome Statute. We have customary law. So we already have a sort of a concept of crimes against humanity. So what would be the additional value of such a convention? And certainly it would be, a fixed definition, a reviewed definition, maybe a consensus that this could be agreed upon. The preventive aspect, I think, obligation on the state to prevent crimes against humanity, that would be something that would be very strong in this convention. And then, I agree with you, Franz, the jurisdiction of the ICJ. I would really think that this is the actual benefit that the international community would have, similarly and in parallel to the Genocide Convention's jurisdiction of the ICJ. So the question would be, to take this out of the draft and then get a stronger share of states, a stronger number of states to ratify the convention. Would it be worthwhile? Or could we then simply, leave it as it is with the Rome Statute and the customary concept that we have? I have a tendency to say, then let's not go for the convention. It's not worth, than the paper that it's written on, because it doesn't add anything on the actual situation that we find ourselves in today. So that's sort of my proposition, and I would like to hear your opinion on that. Thank you.
Well, I would fully agree with that. That's also our understanding. We think there are two elements of it. First of all, in an abstract manner, I think we have possibly three choices: to get a good outcome, to get the bad outcome, or to get no outcome. And the worst is to get the bad outcome, because the bad outcome would be a step backwards. And so this you have to prevent. And then the question is how important is, we think the jurisdiction is really important, because that's a tool to bring us forward. To that. Look at the genocide. I think the fact, I had a lot of discussion with my German colleagues who have now a genocide case, and there are two perspectives to it. The one is, it's great to be part of such an interesting, legally stimulating debate, and to spend hours in your office preparing your plaidoyer. That's great work from one perspective. On the other side, of course, it's a tremendous burden. So I do not want to say that my German colleagues should be very happy that they had a case against them. It is a risk, but I trust the court. I trust the court that it will not take a decision that is totally wrong. So I think I think it is really important to have the possibility. The big question is not necessarily whether we need it or not. I think we need it. It might be convinced by some. The big question is how many states will really renounce to ratify that instrument because we have universal jurisdiction there. There might not be many. Many will say that now, perhaps, but many of those who say that now will anyhow not ratify, and others at the end might still ratify. So, and that is what you were referring to. We have that period. It's 3.5 years. That's a long time, but we need that time to reach out, to understand, to explain, to also explain that this is not the threat. We don't see that as a threat if the case could be brought against Switzerland, because even if if something would happen like that at the end, it's in our interest that this could be brought to the ICJ, because the ICJ might be in a more objective position to make an assessment of the situation than us ourselves. So I think we really need to use the time to explain to those who we think they might be part of the convention at the end to say this is for your help. This is for the benefit of all of us. On the reservation, that's the same. I think at the end, will some states not be willing to ratify because they're not allowed to submit a reservation? I'm not sure. This is the difficult thing to really find out. Is that a conditio sine qua non to ratify or not? Because if you are willing to ratify only if you can put in the reservation, and the reservation is targeted against a backbone, then why wanting that party? It's not. We have to balance between having one party more who is not really willing to live up to the standards, or losing the standards for all the others who are willing to go for it, and that. We do not know now what will be the situation in 3 years, but we have to prepare the ground that we will be in the best possible position when it comes to the final moments of negotiations. And that would be interesting. There's also how do we see, what can we do best to prepare the ground? How can we reach out? I think with Poland and Switzerland we have already two. We know there are others. We have reached out, but how can we organize a process? And the organization of the process begins now. To over the 3 years to have a good outcome.
First of all, a couple of comments on the reservation and jurisdiction. So my reaction yesterday was similar, but then we had a discussion. I said, okay, yeah, that makes sense. Let's talk about it. And about outcomes, and I think it actually connects a little bit with the outreach and the homework we have to do. You said good outcome, bad outcome, or no outcome. Bad outcome, definitely the worst case scenario. If there is no outcome, but there is still a process. There is still something happening. There is a discussion. There is a cooperation, and it creates certain momentum also within membership. So even if there is no formal outcome, there is still a huge added value of these discussions. And exactly, we need to reach out to the silent majority, but this is our work. And I think it is doable. It requires a lot of persistence, a lot of planning, but I think this is something that there is quite a number of countries that are willing to do so. And definitely the conferences like this one helps a lot. Ladies and gentlemen, I think our time is over, and we all deserved lunch. So I will finish now, and I will give the floor to Professor Grzebek.
Dear colleagues, when in the United Nations War Crimes Commission the discussion was ongoing on crimes against humanity, and Czechoslovakia, with the support of Poland, really was pushing to expand the definition of crimes against humanity and to allow to prosecute this crime also during the peacetime, then United States said no, and if you would still insist on it, we stop to finance United Nations War Crimes Commission. This was quite serious threat, having in mind in what state were other governments, especially those governments in exile. Today, we do not need to rely on resources of one big power, and that's why I'm very happy that Poland, having in mind its history, the fact which I would love to stress, that Poland took the effort to prosecute crimes against humanity even before the Nuremberg judgment was issued. Because I would like to stress that Polish courts, they did prosecute the staff of Majdanek concentration camp already in 1944. That the prosecution of Greiser and Amon-Gerd happened before the Nuremberg judgment was issued, and already in those judgments the crimes against humanity were stressed. So having in mind this history, I'm very happy that Poland decided to be very active in the works on the preparatory works concerning crimes against humanity, and support this event. And I do promise that this is only the beginning of all our works. Of course, I would love to say that Poland is supporting also financially this kind of events, because we are 20th economy in the world, but unfortunately International Monetary Fund just announced that we are 21st, just behind Switzerland. But we do not have hard feelings, which I think that to keep the invitation to France and to Gwenaëlle really proved. And I'm very grateful that you came to our conference. I'm very grateful to all the speakers who devoted the time, who sometimes did the new research, sometimes they came back to old research and tried to distill those elements which could be relevant for the ongoing negotiations. But also, I would like to thank to the whole team of Pilecki Institute who helped to organize this event, and I'm really grateful to the support of the Ministry of Foreign Affairs. I warmly look into the direction of the director who agreed to support our conference, and to the colleagues from MFA, to Alexandra, but also to Michał, who secured also the lunch for today, and that's why I'm honored to close this conference and invite you for the lunch. Thank you very much. So I don't know that